Labs rīts visiem no.
Good morning, everyone from Hotel Radisson Latvia at Elizabeth Street. Welcome to the Data State Inspectorate Anniversary Conference devoted to the personal data and future perspectives. Today we will try to look into the crystal globe to see what the future will bring us. I am Oskar Spriede, one of the moderators of this conference, and I'm one of the moderators because this conference will take place on several stages. Also, if we speak about numbers, we have more than 1,000 registered participants from the private sector, from the state administration, everyone who works with personal data, their protection, caring for our security in this context. 1,100 participants, 5 stages, anniversary, 20th anniversary of the Data State Inspectorate. So this is an anniversary year for this inspectorate, and the inspectorate will focus on what has been achieved so far and will also try to look into the future. So to begin the conference, I think I will not be any surprise when I say that we will have 2 official opening speeches. Maybe you will be surprised that there'll be only 2, but the numbers do not always matter. But now we will give the floor to Yekaterina Matsuka, the head of the Data State Inspectorate. Good morning. Good morning to everyone who is listening to us online, dear presenters, dear panelists, dear listeners and viewers. Today we have the 20th anniversary conference of the Data State Inspectorate. So what do? We monitor protection of personal data. And what are personal data? They are like small pieces of a puzzle that allow to create the general picture, us people. And it is, in some cases, it is really good that someone knows all of these pieces of the puzzle, like doctor who treats us. They have to know what has our lifestyle been, what are our diagnoses, what are our illnesses, and so on. If we speak about state administrations, the better the data, the better they can exchange data, the better service they can provide to us, like grant a benefit and so on. But when new technologies enter our life, they change what we do with data and what data can do with us. Like today, we can enter a cinema hall and have our face scanned and recognized. We will be recognized as an individuals, and the money will be charged to our bank account, and we'll be able to go into the hall. Also, our smart fridges can order products on the basis of our diet or preferences. Also, the cameras can be installed in public spaces that allow to recognize faces and, so to say, catch all the criminals that are wandering around. So this is no science fiction. This is a reality already. These technologies already exist. But then there is a question whether we really have to live in a world where we are never alone, where always someone watches over us, where there are devices, platforms that surveil us, monitor us, analyze our behavior, and make conclusions, and basically choose instead of us what we like, what we don't like, what we have to watch, what not. For whom to vote, with whom to be friends, and so on. Do we really want these things to be decided for us? Because people have been fighting for freedom, for independence for hundreds of years, for the possibility to be different, to be individual, to make the decisions for themselves. But now, for the sake of convenience, we give the choice to our devices and also to the companies behind these devices, as well as platforms that support these devices. To win in a lottery, for example, to receive sneakers, people give data to faraway company on the other side of the ocean, and they are not really interested who accesses this data, how they use this data, because they just want these sport shoes. Many already say that we have lost the battle because all of our data are wandering somewhere around in the online space. But then there is a question whether we have really lost the fight, because the data regulation allows us to take control over our data, to carefully monitor who uses our data. Also, we have to be careful as to what we post online, to whom we give our data, and how much. The data regulation was created to protect personal data and the society, considering risks related to mass processing of personal data. It was not meant to solve individual, the so-called neighbor quarrels. It was made with a global context in mind. And this is actually the approach that the regulation has taken, how we can protect the society, for the society as such to freely decide who and what will be done with our data. But then we have to ask, does the society really need that? Maybe this is just one of the recent trends, development trends in the society. We want to give up our privacy to gain comfort and convenience. Maybe we give up privacy to get something better. And then we have to ask, can we really protect our data in this context, not to process data more than we need? Can we really find a balance between the freedom of choice and these other considerations? And this is what we will discuss today. And we'll also discuss these matters during our panel discussions to understand what is data protection and what is the future of the personal data. I wish all of you a very successful day, many new ideas, knowledge. Thank you. Thank you to the Director of the Data State Inspectorate, Ekaterina Matsika, who had very relevant words to open this conference. There were many contradictions in her opening speech, like personal freedom, protection of data, personal choices, loss of privacy, and so on. And these are the matters that we will try to solve on our 5 stages. Currently, we work only on one stage, but later I will tell how you'll be able to navigate this information jungle during the day. I promised 2 opening speeches, but the second speech will be in a video format. And now we will give the floor to Raivis Kronbergs from the Ministry of Justice. Congratulations to the Data State Inspectorate and colleagues on this anniversary. Personal data in the digital world are an important resource to change our habits, interaction with other basic rights, in particular the freedom of speech and the right to privacy. These and similar challenges are faced by the entire European Union to ensure the same level of high level of protection of personal data by means of new technologies, as well as processing of personal data when personal data are processed in third countries. This means that we need a proper protection of personal data to ensure trust between individuals, employers, service providers, and so on. And we also have to understand that we need people in protection of personal data that are able to improve their knowledge. My wish to you, employees of the Data State Inspectorate, is not to lose your vigilance, to provide support in the future in this area, and to continue what we have already started, namely working together. We will discuss these issues, complicated issues, in the format of think tank. I wish a very fruitful discussion to all the participants of the conference. The conference is called Personal Data and the Future Perspectives. Thank you. thank you to the State Secretary of the Ministry of Justice, Raivis Kronbergs. So the official opening speeches are over, and now I will provide information on the logistics of this conference for you to be able to follow what will take place today. Currently, we are online virtually, almost all of you, on the Alfa stage. To the right, on your screen, you will see a section with several smaller icons, like a comment section where you can provide your opinions, so to say, network online. Then there is a P icon. That's where you can try various questionnaires, like answer to the question how you feel today. I see that everyone has said great or excellent. And also in the same section, next to the questionnaire, there is a calendar icon, and this is the agenda, the program of the conference. Depending on the stage, you will see the respective program, and also depending on the time, you will see what will take place in the nearest future. Also, if you have found a topic that is of interest to you on Delta stage, then on the top at the respective time, please click on the large blue button Delta, and then you will be forwarded to the Delta stage. We were asked in the comment section how to switch languages. That is on the same screen where you see me. You just have to go hover over with the cursor on this video, and then you will see like an ear icon, and then you'll be able to choose the respective language that you would like to listen in. Now it's 10:12, and I think I have said everything that was related to the logistics. Now we will have a short break, and then exactly at 10:15 we will restart our work on all stages that we have planned today. Thank you.
Right here, I saw me a pretty young gal. Girl was looking like yeah. She was looking like nah. You know what I'm saying? But the girl talked too much. I told her it could be all real simple. It's a real simple process, this love thing. That's what I tell her right here. I said, you feeling me and I'm feeling you. What we gonna do? Shut up and group. Shut up.
No re, esam atpakaļ uz.
We are back on the Alfa stage. Probably you saw that the timer has already ended counting, and we had not started yet because the guys could not find the button to switch off the music, but the button was found, and now we can resume. And at least on Alpha stage, we will have two parts, and the first part will be devoted to finding a balance between the interests of the society and individuals in the banking sector. You know, when you go to the bank, maybe you want to open an account, the bank really wants to find out a lot of information about you. And after the adoption of the famous data protection regulation in Europe, a lot has changed for the better if we speak about the rights of the individual. But at the same time, various events like global terrorism and so on, they have changed a lot for the worse in the world. Then we also have to take into account the famous AML regulation framework. And then there is a question how we can find a balance between all of this for us to, as a society, to develop, and the same pertains to businesses as well. In this section, we have several speakers, and I'm very honored to give the floor to the first speaker, Wojciech Wierowski, who is the main person in charge of protecting personal data in Europe. So he is the person who is actually taking care of protection of personal data in the entire Europe. And judging by his name, you have already understood that he is from Poland. And he's also the author of various studies and also an experienced presenter and lecturer. And he will speak about the following topic: how to legally introduce AML directive without violating the right to privacy.
I believe we don't hear you yet.
That's why. Now you should hear me, I guess.
Yes.
Okay, so welcome and thank you very much for the invitation.
All right, if you're ready to start, the floor is yours.
Great, thank you very much. So then, greetings from Brussels. Brussels, which is quite cloudy today. And I know that Latvia is going through the next part of the strange procedures and strange situations that we have because of the COVID pandemic. I don't know if it makes you a little bit more, at least smiling, but I have to say isolate myself as well. Since a few days ago, I was in contact with a person who was then tested COVID positive, and despite the fact that the tests have not revealed any viruses, it makes more sense for me with this program that I have for this week to stay self-isolated, because Brussels is this week the venue for the European Data Protection Board meeting, the first one in the real world after the COVID time, and also the huge Congress of Data Protection. So locked somewhere in the in my neighborhood in Brussels, I'm connecting with Latvia. I'm connecting with Latvia because I would like to stress the importance of the countries of our region, I may say, because I come from the same region. I come from the country which joined the EU at the same time with Latvia, and which tried to be very operative at the beginning of its of the time when we belong to the EU, but which also shows that the path from being the leader of the changes to being a kind of outsider of these changes is quite short. And we have to be really very careful about the state of the democracy and the rule of law in the EU countries. I'd like to talk about it in the scope of the discussion about the financial sector, about the banking sector, and about anti-money laundering. I will not be that much addressing the problems of financing the terrorism and the measures which are taken by the the European Union, I'm rather going to focus on the problems of anti-money laundering, because anti-money laundering as such, though goes in a kind of maybe not conflict, but a kind of balance with the privacy laws, at the same time shows how flexible the approach can be if we really take into consideration the two main principles, the two main values at the same time, which are the necessity of the intervention, of the legal intervention, and proportionality of such an intervention. So, as you precisely know, and as it will be, I guess, said also later on during the conference itself, we are at the next stage of anti-money laundering developments in the European Union, which were purely caused by the problems that we found last years, and especially the Danske Bank scandal, where more than 200 billion euro have been strangely flowing through the banking system in the European Union, and we had problems to find out actually what the operations were, who are the beneficiaries of these operations, and how they impact the market itself. In May 2020, the European Commission has announced the plan that tried to answer the questions that we found last years. And the primary aims of this plan were to ensure that the effective implementation of the existing AML regulations can happen. The establishment of the single rule book for AML for the EU, and also to enforce the EU level criminal law provisions on information exchange, and to establish the support and cooperation mechanism for the financial intelligence units. That was the part which the European Data Protection Supervisor was especially interested in. And also to strengthen the international dimension of the AML framework. Let me say first, why EDPS, why the European Data Protection Supervisor, and what is the role of both the European Data Protection Supervisor and the Data Protection Authority in the member state, like it is in Latvia. Well, the European Data Protection Supervisor is the supervisor of the EU institutions, bodies, and agencies, while there are still 27 jurisdictions in the member states in the European Union. So I'm not somehow supervisor for the whole Europe, and not in any sense over the Data Protection Authority in Latvia. Simply, we have a slightly different scope of our activities. If you come to Brussels and you have the problem with the hotel or with the shop in Brussels, you go to the Belgian Data Protection Commission. That's the one who is responsible for that. If you have such problems with the European Commission, European Council, European Parliament, European Central Bank, and any other agency that exists either in Brussels or in any place in Europe, then that is the European Data Protection Supervisor who is dealing with it. But what is more important for our today's discussion, EDPS, European Data Protection Supervisor, is also the main advisor in the legislative process in the European Union. So when we have the sixth package of AML going through the Parliament and through the Council and being prepared first by the Commission, this is mainly the European Data Protection Supervisor who is providing the opinion, and we have provided such an opinion in September 2021. I'd like to remind that on 12th of July 2021, the anti-money laundering package has been revealed by the Commission. So something which based on this plan that was announced a year ago. And then on 22nd of September, EDPS has presented its opinion. And I guess this opinion is a good example of the approach that the data protection authorities generally have towards the anti-money laundering legislation. First of all, we welcome the existence of this legislation. We think that the fighting the frauds, fighting the problems that we have sorry, I have to remove one of the programs which is now causing additional sound, which is not necessary for us. Okay, no problem. Next, I guess. Trying to fight with the frauds that exist in the financial system is a mere duty of the European Union institutions, and one of the things which we also, as data protection authorities, should take part in. I'm also sure that the exchange of data between the authorities and also between the parties that are taking part in the financial market is the prerequisite for such a cooperation and for such fine. So AML at the same time, anti-money laundering legislation, has proved to be effective, and that's incredibly important. Because even if we think that it's something is necessary and has to be introduced into the system, we have to assess the proportionality of the solutions. And the proportionality is based on two legs. One leg is how far you go in the intrusion into the right to privacy. The second leg that you have to take into consideration is how effective is this intrusion. And let me, at the very beginning of the conference, compare the solutions that are entering the privacy of the persons and which are in the AML regulation with the other regulations which we as data protection authorities are much more protesting against, like, for example, passenger name records systems that are collecting the data about the passengers around Europe. While with the AML, it has been proved very precisely what are the effects of such an intrusion. It was not done with the PNR. So we can see that the AML regulation in this sense is much more effective. And also the steps that are taken are going directly to the results than it is in the other fields. So what then we can find in the opinion of the data protection authorities and what the EDPS has found in the opinion on the legal act. This legislative package is prepared in the right way and is prepared with enormous reference and enormous recognition to the privacy and data protection issues. But at the same time, there are some shortcuts that have been done in the legislation, which we probably should work on as well. So the ensuring the compliance with the data protection principles of necessity and proportionality, as well as with applicable union members and union member states data protection law, is the core of these solutions. The AML legislative package should identify more precisely what categories of data are to be processed by the obliged entities to fulfill the obligations. In particular, the proposal for the regulation should provide the clear indications of the personal data, of the conditions and the limits for the processing of the special categories of data, and the personal data relating to the criminal convictions and offenses. Concerning these special categories of data, AML legislative package should specify precisely which type of data should be processed by the obliged entities. The traditional problem that we find in the AML legislation is the beneficiary ownership and the treating of the data which allows to find the beneficiary ownership solutions. While we fully understand the need for dealing with the real beneficiaries of the AML actions, we have the doubts in the scope and, let's say, the broadness of the access to the information on that. While it's absolutely understandable for us that the information in the scope of the information should be allowed and should be accessible for the tax authorities and the other state authorities that are taking part in the processes, we think that the so-called transparency part of the regulation goes a little bit too far. We fully understand the need for the civic control over what's going on there, civic help towards the authorities, but definitely the access to all this information given broadly to everybody in the world is against the principle of proportionality. So while we think that the access by the authorities is regulated in the right way, the only competent authorities who are in charge of enforcing the law and obliged entities when taking the custom and due diligence measures should have the access to the information. And we remark that the access to beneficiary ownership information, for example, by the NGOs, may be done, may be organized, but it should be actually done slightly differently. We should rather think in this sense as the right to obtain and to provide the information, not the freedom to access to the information. So such a public access responding to different functions and different purposes should be the subject to the different test of necessity and proportionality. Having regards to the data relating to the criminal convictions and to offenses, the reference to allegations in addition to investigations and proceedings and convictions in the text of the proposal is, in our opinion, the very good example of some vague expressions, and therefore it should be deleted. And let me stop here for a while, just to comment one more thing. The big advantage of working with the financial industry, with financial markets for the data protection authorities, is that generally the precision of the notions which are in use is much bigger than in the other fields. Let's not lose this advantage. So far, we were especially good in the financial sector in finding out precisely what the persons can do, what is the scope of the access to the data of the clients, and what are the operations which are done with the data. We are generally, as data protection commissioners, kind of allergic to the notions like fighting the frauds or countering the frauds, because we neither know what the fight and the countering means, nor what the fraud is. So let's try to be precise with the information that we give. So let me then conclude by saying once again that the anti-money laundering proposal from the Commission that is right now on the table, and which also will be the part of the discussion during this conference today, is generally welcomed by the data protection authorities. But at the same time, all our comments and remarks on that are going in the direction to not to lose the advantages that AML regulation had so far over the other intrusive measures that are proposed in the European law. That here the purpose is quite clear. The law that we have at the moment seems to be quite precise. So if we want to amend it, if we want to make it further, because we find that there are the new needs, let's not lose the advantages that we had so far. I hope that you will have the wonderful conference today in Riga. Once again, let me congratulate for the recent developments in Latvia, especially as far as the Data Protection Authority is concerned. I think that it has been proved last month that Latvia is one of the most active countries in the discussion about the effective, but also, let's say, reasonable approach to the data protection and privacy in the new world, in the new post-COVID Europe. Thank you very much.
Thank you, Wojciech, so much. And I see you shortly in a panel discussion that will be the conclusion part of this first section of Alpha Stage agenda. So let's now move on. Pārslēgsimies varbūt mazliet.
So now let us switch to Latvian because we will have a sister organization in Lithuania represented here, and I am talking about data inspectorate in Lithuania, and we welcome Raimons Andriauskaitis, and he is going to talk about anti-money laundering measures.
Kas naujo Lietuvoje?
Lietuvoje daug naujo. I probably wouldn't talk in Lithuania.
Exactly. All right. Yes. Good morning, and the floor is yours.
Okay. Thank you very much. Good morning to all, and many thanks to organizers for the given opportunity to participate in this event. And I hopefully think that the discussion will be fruitful, and all the issues that relates with data protection and MAL requirements would be covered. First of all, I would also like to congratulate Latvia and Latvian peoples with the upcoming Latvian Independence Day. So very congratulations to you, and hopefully we could be together as we are the 3 Baltic countries and achieve our goals and also protect personal data. So I'll start with my presentation. I'm starting to share my slides, and hopefully you could see them. Okay, I'll start with my first slide, and in this first slide, I would like to start. In the first slide, I would like to start with a brief context as what are the tensions between email and CFT requirements and the right to privacy and data protection. Why we're talking about this, I think that it could be very useful to understand the difficulties that we are facing while implementing ML and ML measures, and those measures that are in line with the GDPR requirements. So first of all, the objectives. We see quite different objectives, and we think that both objectives are really important, and we have to balancing between them. It's worth to note that ML and CFT objectives couldn't be achieved without large-scale processing activities of personal data. So here we have some kind of line where we have interference between those regulations. Second very important point is who decides on the game rules. In the field of ML CFT, we have international organization. It is Financial Action Task Force, and this means that the participating parties are obliged to implement standards and recommendations that are issued by this organization. As European Union is just one of the members of this international organization, it means that GDPR requirements are not obligatory for non-EEE members of the Financial Action Task Force. And it also means that decision-making procedures could be very different if we think that GDPR requirements could be implemented in those standards and recommendations. GDPR without backing of international organization, even if we think about it as a golden standard for personal data protection, still remains a regional act with limited possibility to impact decisiveness of international organization. And thirdly, we should also understand what are approaches and what are dominant approaches when deciding on implementation of email measures and personal data protection requirements. In the email CFT field, we can find zero tolerance, gold plating, or reputational risk approaches. And what is common between all of them, that each case where money laundering or financing of terrorism appeared, it is unjustifiable. So we declarate, email supervisors declarate that they'll take all possible means to prevent from anti-money laundering activities or anti-money laundering activities. So on the other hand, as we look at the GDPR approach, I would say it allows and even requires to balance between different public interests and find the best possible solution how to have fair balance between the interest to prevent money laundering and terrorist financing and the interests underlying the fundamental rights to data protection and privacy. In this second slide, I wanted to show how simple is the process of ML and CFT implementation. Fine, okay, probably I just wanted to make a you to smile because when we add personal data protection requirements to this particular scheme, many questions arise that causes probably headaches because of the complexity of those questions. In theory, it could be quite clear what these procedures are and how should they work, but when we try to apply GDPR requirements to these data processing operations, we are facing a lot of difficult questions. For example, which categories of personal data we use in each of these measures, how to implement data minimization principles, what is the accuracy of personal data that we receive, and many other questions that arise when we are thinking about the data processing activities. So, the best way probably to start about thinking how to implement these requirements, probably we should look into the scheme, and in particular in the first points that are supervisors. And what is interesting about ML CTF supervisors? Here we can see a slide. I took example from Lithuanian law on ML and CFT and tried to count how many supervisors are mentioned. And I counted 12 of them. We probably all have a central bank and financial crime investigation service, but we also have more other 10 competent authorities that are responsible for supervising activities. And they not only supervise, but they also are empowered to adopt particular detailed requirements in the field of their supervision area. So to put it simply, the number of different categories of personal data could vary greatly, even implementing the same KAC program within different areas. And that's a point that we have to think and bear in mind when we are thinking about ML and personal data protection. Interesting point that also was noted in the European Commission conducted supranational risk assessment is related with the relationship within the company as itself, and in particular between the main company, main establishment, and their branches. Each branch of the company must implement those ML requirements that are adopted in that member states in which that particular branch company is established. So even within the same company, the implementation of ML measures could be quite different. Actually, I even a little bit afraid to imagine how this kind of scheme would look like if the company has branches in all the EU member states. So we have some kind of like molecular system with different supervisors and also quite different requirements in that particular country. And in this slide also we see and could compare ML supervision system with the GDPR supervision system. And without going deeper and digging deeper, I just want you to try to imagine how could main establishment reasoning be why data minimization principle is differently applied in its branch companies. And do we think that answers related to national law requirements will withstand a critic when we have a common field of common playground in this field? So let's go to the real anti-money measures, and as we probably agree, the core measures are KAC, CDD, and enhanced CDD programs. Even though sometimes they are named just as KAC, but separation of these measures and understanding them accurately would be very important, especially in the context of personal data protection. So KAC, or Know Your Client, is described as checks that are carried out at the beginning of the customer relationship with the purpose to identify and verify the customers, that the customers are who they say they are. So KAC also includes creation of customers' risk profile by collecting their personal data and identity documents. Second measure, also very important in the ML system, is customer due diligence, or CDD, and this measure is related with ongoing relationship with customer. It allows assessment whether the information provided by customer under during the beginning of their relationship is correct, and it also aims to reveal the potential risks with particular customer by monitoring various sources. And here CDD is a type of probably CDD, and it used to describe higher scrutiny procedures, and from the data protection point of view, also greater interference to private life. And those activities and HCDD activities and scrutiny procedures are in cases where customers' activities have higher risk. And the risk could be based on the country or geographical location. Also, the risk could be inherent to the customer itself or client itself, and also could be related with the type of transactions. So when we are thinking about data protection requirements, a lot of questions arises when we are looking in the possible implementation of these measures. So to not struggling answering those questions, probably the best way is to come back to our regulations and to look how it could help. But what we face is that it's not really simple, and that is like a cold shower to us, because ADPB in its statement states that there are no clear legal basis for processing of personal data, and also there are no particular purposes, and also the limits of such data processing are in question. When I tried to find answers in our national regulation, in our Lithuanian law, and I was quite shocked, because I see wordings like no less data than depending on received information from reliable and independent third party, and also quite interesting wording was, it is permitted to request other data or other information from the customer. So as here is probably not much time left, just to finish my presentation with last slide about suspicious transaction reporting. So I don't talk about definition, but how it works. All the data received during KIC and CDD programs are analyzed based on existing risk management model, using automated processing, profiling, and decision-making techniques. Suspicious activities are identified, and notification or filing systems are used to inform financial investigation unit. While receiving feedbacks from FEU, related customer activities are suspended. In this case, having in mind the negative impact of this kind of personal data processing, that personal data processing could cause, it is really important to think about data protection requirements, and special precautions is needed by responsibly implementing data protection impact assessment. So it's all at now, and I'm looking forward to having panel discussion later. So thank you.
Thank you, Raimondas. That's exactly our plan, so see you in the discussion very shortly. Bet nu mēs turpinām programmu, un mūsu nākamā runātāja ir tepat.
But now we continue the conference, and we return to Latvia, and our next speaker will be Laima Letiņa, who will tell about occasionally controversial topics of AML framework, and how that goes hand in hand with the General Data Protection Regulation. She is from the Association of the Financial Industry, but she has worked for a long time in the private and public sector, like the Ministry of Justice, where she worked on preparing various legal frameworks in the commercial law and the money laundering area. And this interaction is one of the foundations of her professional activity in introducing various legal frameworks at the normative level and also in practice. I think I have already told half of the content of your presentation. Please, the floor goes to you.
Thank you very much for the introduction, and I hope you can hear me and you will be able to see my presentation in a moment. I should ask the organizers to put my presentation on. I think we can do that. Zoom has a subtitle, technical issues. We have a plan B, and we can share the plans from here. So I will start, as you've said. My name is Laima Letiņa, and I'm advisor to the organization, and I am the only specialist of AML in the middle of specialists of GDPR. So it will be interesting to see how our areas coincide. We talk a lot that AML and GDPR is a battle of two titans, but actually the interest underneath those two areas is the same, and that's what we do. Namely, no one wants to allow our financial system to be used by criminals or to launder money. At the same time, to protect private data of oneself or of the others for subjects of private sector, namely banking sector and others. It is due to several reasons, and I will tell about them. Speaking about AML, we know one sentence, and it can be directed to both areas. Namely, if you think that compliance is expensive, try non-compliance, and you will be able to understand the meaning of it. Next slide. Speaking about expensive, we usually think of losses, monetary losses. Those losses are much wider, and sometimes they are of longer duration, namely in cases when banks are not diligent enough and the banks are used for money laundering, as well as in cases when personal data is being accessed as not meant, then the bank or another organization is subject to losing reputation and trustworthiness, as well as safety and sustainability of operations that might be questioned, and cooperation with cooperation partners and clients would be questioned. Of course, speaking about money, we like to measure everything in money. So let's talk about figures, thinking that GDPR part has bigger fines, because at least there are bigger fines mentioned in the GDPR directive, more than MLA directive. In practice, you might have to take out your revenue of the previous year, and you have to calculate the fine according to the revenue of the previous year. And sometimes fines are calculated depending on the area, violated area. But evaluated from a financial area association, whether those areas are so different, I have to conclude, although that in on daily basis and some specificities, there are collisions and clashes between those two areas, and we have to think how to satisfy both areas. GDPR and MLA areas are both very similar. So all activities have to be done with when necessary. Both regulations are not indeed elaborated in detail, as well as it is mentioned, the supervision is very stringent in both areas, as well as fines are rather high. In the context, understanding that those areas, although being discussed about their correlation, and this is the topic of today's conference, there are similarities in those areas, and we can see them in our practice. But in order to see them clearly, we have to get involvement from the supervisors and legislators. They have to cooperate in order to harmonize those areas. And I have to praise Lithuanian Data State Inspectorate notice that the legislators should elaborate an impact on data protection, because we have already found out that this impact can be questioned, namely MLA activities on dealing with personal data is for the benefit of the society, but there should be other discussions how maybe it can be solved in a different way without jeopardizing personal data. We have big challenges to ensure this balance when working with personal data. And being very open, I have to say that the private sector has to perform activities similar to law enforcement bodies. This is not a breach, or this is not a content, but when you come up with those kinds of obligations, you have to evaluate future impact on dealing with personal data, on processing personal data. When speaking about AML, in Latvia, as well as the new package from the Commission, we are more dealing with risk-based approach. But first, we need to acquire information in order to place the person in a certain level. If the information is there, we cannot place the person in a certain category. Speaking about AML and personal data processing, information that today is not significant and that might be not decisive and that might not be processed will be decisive tomorrow when the person, for example, transfers a lot of money. So the dilemma is there whether to process the data or not. Also, big significance is the following, that not all the data can be verified, especially in the area which is close to AML. Talking about sanctions to Belarus, and by evaluating whether it is possible or not to transfer means to a private or natural person in Belarus, and this information is not there. Neither FIU nor bank authorities do have all the information on citizens or institutions in Belarus. And we have to ensure this balance, which is usually being found by the institutions. We are working together with Data State Inspectorate as well as Financial Inspectorate, and we will come up with guidelines in order to ensure all the fulfillment of the requirements of AML-TF, ensuring requirements of GDPR. And we are very thankful for the involvement of both institutions. First of all, we talk about the rights of data subject. And these rights are somehow violated, taking into account the processed data. Talking about circumstances, how and when data is being protected. In AML case, most of the data mentioned in the regulation is processed. For example, legal obligation, that is a primary basis, and this is prescribed by the law in order for service to be provided, for example, by the bank. That's why we encounter in some cases resistance from clients, and in those cases, services are not provided. Also, there is an obligation of identification of the client, as well as identification of the origins of wealth. Also, second, interest of the society. We have had many discussions when these interests prevail, and the decisive opinion is the following, that interests of society should be placed first when AML data process requirements can be fulfilled, but the subject has the subject or the obliged entity has rights to look in open source data for the benefit of the society. In addition, there are cases when data are being processed on the basis of legitimate interests. We are talking about cases when we have to evaluate whether the data should be processed for the interests of others. Most typical case is the following. The safe keeping of data for longer than 5 years is necessary for future litigations, etc. And assent. Assent is the fourth pillar, and the assent is being required in the form of, for example, informing the client of novelties in AML CFT, thus automatically giving his or her assent. Rights to be forgotten. Those rights are limited because we keep the data for at least 5 years, and this can be prolonged. Bank has an obligation to keep the data, and it prevails over the rights to be forgotten of the data subject. Data minimization. GDPR basic requirement is to collect only the data that is necessary. And I think it doesn't contradict to the requirements of know your client or customer due diligence requirement. And those are mainly based on internal regulations, internal documentations, because supervising authorities should be able to explain the necessity for the necessity of this or that data in the process of CDD. Also, principle of transparency. This information has stringent limits in case of AML, and bank is obliged, if tipping off, for example, a client shouldn't be informed that he or she is being monitored, or there is an SDR filled in on him or her. That's why we are trying to get as much information as possible without the involvement of the client, but by informing client of all the procedures in all the procedures of GDPR, as well as privacy statements that we require from the clients. Also, precise data. The data should be renewed and should be precise. We have to take into account that some part of the information cannot be disclosed to the client within the procedure of AML CFT, and not all the information should be registered, because that might be risky, and that might disclose unnecessary information. It is important that in this case, renewal of the data is ensured from official registers, and we have assent from FIU and other supervisory authorities that the renewal of the data can be done without requiring the information from the clients and without the assent of the client. So we don't need a client to be involved. In addition to giving information, if this information is already submitted to, for example, an enterprise register or another register. And now 6 advices how to reach this harmonization of AML and GDPR. First of all, you have to identify the overlapping zones where those two areas overlap in order to understand how to observe all the requirements and fulfill one's obligations. Also, there is a requirement in both areas that documentation should be precise and well-based. These activities has to be balanced, and there should be balanced with the risk, the highest level safety and integrity also is there in both areas. Speaking about IT perspective, data integrity in order to ensure the quality of data and to reach all obligations required by MLA and GDPR, as well as balanced and risk-based approach is a direction that European Commission has now taken, and that has been followed in Latvia in the last years when processing personal data, namely not to over-process the data, but at the same time to act within the scope of both areas, GDPR and MLA area. Thank you very much. I look forward to panel discussion. Yes, indeed. We have one more lecture from Veronika Sayadova. She also works in the working group of GDPR in Financial Association, but on a daily basis she works as certified data protection specialist. And on a daily basis, she works in Swedbank. Do tell me who doesn't have an account in Swedbank. I think the majority does have. She's going to talk about client identification and obtention of data. Please.
Hello to everyone. Thank you for introducing me, and thank you for invitation to this conference. I will definitely tell you about who has an account and who hasn't. But On a serious note, I will now share my presentation. Just a moment. I hope that you can see it now. In a way, I will undermine the topic that is the topic. I will undermine the topic of this conference. The personal data are the future perspective, because it's already a reality. Personal data are already very valuable, and the value depends on the purpose of processing. Depending on the purpose, various legal acts can be applied. And considering the fact that this section is devoted to the banking sector, I can say that the banking sector and the financial sector in general are one of the most regulated. And it means that a processing of data takes place because it is required by the law applicable to banks. Accordingly, the purpose of processing should be found in the respective legal act. And it may happen that the processing is regulated not only by one, but by several legal acts, like, for example, in the case of customer identification. Because first and foremost, we have to comply with the General Data Protection Regulation that undoubtedly is the star of today's conference. And as we can conclude from its title, this regulation lays down general requirements that apply to processing of data, and these requirements apply to all supervisors, to all and then credit institutions in particular are subject to the credit institutions law. And according to this law, such institutions have to ensure that the accounts and the transactions of a person are kept secret. And this is a so-called banking secret. So returning to your question, information about who has accounts in specific banks, or if customers are customers in a specific bank, this is a banking secret, and we have to keep it secret. Third, in the AML area, there is also a special law that is applicable to the parties being parties that are subject of this law. And according to this law, banks have to identify persons with whom they intend to start business relationships, or if they already have these business relationships. So as you understand, this is done for a specific purpose, because it is required by various legal acts. And if this requirement was not imposed, any person could pretend to be another person and access personal data of this person, and as well as his or her financial means. Thus, when banks identify their customers, they not only comply with these legal requirements, but they also act in the interests of customers to mitigate the possibility of customer service abuses. So customer identification at a bank contains a set of measures, or is made up of a set of measures that determine how customers are served. There are two types of service, in person or remotely. So if in person, the customer has to come to the branch of the bank, the identification is performed by an employee of the bank. The customer is asked to produce a proof of identity. For residents, it's either an ID or a passport, or for non-residents, it's another document that has been found valid to travel to Latvia, like, for example, residence permit. And when a person is identified in person, the employee of the bank compares also the visual appearance of the customer with a photograph in the personal ID. I have to say that COVID has created at least one challenge, because you know it very well that if someone comes to the branch, he or she has to wear a mask, and the employee of the bank can ask to take off the mask for a second or so. And so please understanding and comply with this request so that we could actually perform the visual comparison. What else do? We visually verify the produced proof of identity to make sure that this document doesn't have any signs of falsification and that it is not damaged. It is also compared with register of invalid documents to make sure that this document is not stolen, lost, or voided. And all of these activities are performed by the employee to make sure that the identity of the customer is genuine. Otherwise, the customer service session should be discontinued. But if everything has been found valid, then in most cases this proof of ID is copied or scanned and added to the customer's file. And then when people ask why do banks copy or scan proofs of ID, is still one of the most popular questions that people ask in branch offices. And for this reason, I will explain once more. According to the AML law, customers have to produce a proof of identity, and the banks have to make a copy of this document, either on paper or electronically. So this is the duty of banks. If this was the first time session, the acquired data and documents are entered in the system, but during next service sessions, the current data are verified as to their correctness and topicality. And this was just mentioned by the counselor to the or advisor to the Association of the Financial Sector, namely, according to the data regulation, we have to process only correct, accurate data and updated data. Second, according to the AML law, we have to ensure that the acquired data and documents are updated in due time. So, unless this is an irregular transaction, accidental transaction, customer identification is a regular measure, and it has to be done when a person arrives in person. But since customer needs can be diverse, the customer may be also asked to produce other documents, like, for example, when customers represent someone else, another individual or legal entity. So in this case, the customer can be asked to produce other proofs of identity and representation. Second option, when a person contacts the branch office online, and this requires remote identification. For example, a customer is asked to connect to the internet bank, or when a customer calls to the advisory center, or when a customer calls via a video call. In this case, the customer is identified according to the authentication means issued to him or her, like the user number and the smart ID or code calculator. And I would like to remind once more that when the bank calls, the bank will never ask you to provide codes, neither the card codes, nor smart ID codes, nor code calculator codes. So please remember that it is very important not to give these data to third parties. But if this has happened, if they have acquired these data, please inform your bank immediately for the bank to react as quickly as possible and stop these transactions, like blocking the card or stopping the transaction transfer. As to online identification, I should also add that in some cases it cannot be compared to in-person identification, and it means that service options can be limited. But of course, these possibilities change and develop. in particular considering the COVID challenges, considering meeting restrictions and in-person service restrictions. It is just logical that whatever we do in professional life and private life becomes more and more virtual. At the end of my presentation, I would like to remind that a customer identification takes place because it is required by the law. The bank performs the identification to comply with these legal requirements and to act in the customer's interest to ensure the protection of customer data and financial means. Thus, it is very important to update your data in due time for the bank in turn to comply with this requirement to process correct and updated data. So if any of your data change, for example, surname or personal ID number, please let the bank know in due time. Thank you for your attention. Keep safe and keep your data safe as well. Thank you for your best wishes. Nowadays, it's very popular to wish good health and good luck in avoiding COVID, but your wishes were very relevant and very topical. Thank you, Veronica, for your presentation. And now let us continue with the next item in our program. We still have an hour until 12:30 when we will have a break. And now we will have a panel discussion with the previous speakers. It was with the exception of Wojciech, because he had some very urgent matters to deal with in Brussels. So I hope that we will do great also without him. So we'll have the following panelists: Ramondas Andrijauskis, Director of the Lithuanian Data Protection Inspectorate, Laima Letiņa from the Association of the Financial Industry, and Veronika Sjadova from Swedbank Group in Latvia, Data Protection Officer. And we will also have Jānis Timermanis, the Chairman of the Board from the Credit Association. So this is a body that knows quite a lot about us. It seems that we will have to continue in English.
Environment and this conference, we're switching now to English, and we will be talking in English mostly in this panel discussion. So why don't we hear some few introductory words from Jānis, since he's the only one who has not been speaking in this conference today.
Thank you. A few words about the company I represent. KIB, or Credit Information Bureau, is majority owned by Credit Info, and Credit Info is operating in more than 30 countries, working with both personal and company data on a daily basis. That's, I think, in short. Thank you.
Okay, so I have quite a long list of rather specific questions, but I have no doubt that you would be capable of both answering them and also commenting, and hopefully also having a real discussion with some opposite opinions. If that's the case, we'll see. So my first question goes to everybody. We'll see who's more keen to be the first to answer it. So what do you think? Is it compliant to use in the bank's customer investigation data gathered and maintained by service providers registered in third countries, such as World Check, for example? And could banks provide customer due diligence without using data from such databases? So whoever feels capable of answering this one, please step forward.
Maybe start, probably, yeah. As a supervisor, I look at the regulation and try to find possible ways to use this data, because I think that we all agree that customer due diligence and know your clients are quite important in the whole email system. But from data protection perspective, I have few doubts, and probably it is the legislator's duty to answer them, because in Lithuanian law, I see the possibility to use third parties' data, but then we have to know who they are and who those third parties are and on what legal grounds they are processing that data, because then when comes the institution that implements ML requirements, we also talks and investigates them from whom they receive, do this data is relevant to their operation and so on and so on. And if you have a counterpart who is not really responsible using or don't have legal grounds for using personal data, so it could be a shadow also for you who are working in the field of ML. So probably I'd say it is possibility, but we have to be careful about our counterpart.
Right. I see Laima is also ready to comment on this one.
Yes, thank you. I totally agree with Raimons regarding that we need to be careful with regarding with who are from who we are receiving these data. It works in all situations that you need to work through this reputation of those companies, etc. But about practice, well, here in Latvia, I would say that it is a requirement in cases when we are servicing high-risk customers to use such databases. Theoretically, it is possible to not use exactly third country databases, but in these cases, bank need by bank herself make that kind of investigations, and in those cases, it would cost a lot. And as in private sector, the payers, of course, would be the clients of the bank who would pay for such kind of data processing. The hardest thing maybe in these cases is to explain and justify why it is in compliance with purpose of the data processing. But as I already explained, the risk-based approach is the one who is playing the central role here in cases where we are talking about pensioner who receives only pension. Of course, it is not relevant to check that kind of databases, but in case if we are talking about persons who want to act in all kind of countries and make payments and receive payments with big sum of monies, it will be the case, and there probably aren't any better way how to make those checks. Thank you.
Right. Let me step to the next question, which is, I think, a big contradiction, but you may correct me, of course, if I'm wrong. Yeah, so one of the guiding principles, basically, in data protection is gather no more data than is actually needed to achieve this legitimate purpose. But then this know your customer and his partners, it seems like it involves knowing a lot about the customers. And do you also consider that there is a contradiction between those two rules? One is like have it as little as possible. The other is know as much as possible and as you think you need. And yeah, so let's have both visions, both from financial institutions perspective, and probably I would then address this to Veronica, and also from the supervisory authorities point of view, Raimonda. So let's start with Veronica.
Yes, thank you very much. And you know, the question that you have asked, I hear actually very often, especially from AML specialists, because they are of the opinion that AML and GDPR regulations have opposite vectors, you know, like going into opposite directions. But I think that the GDPR and AML go together, like hand in hand. They support each other like in a team. So they should be applied simultaneously. And when that happens, there should be no contradictions. For example, On the one hand, the GDPR states that you need to process the data only if you have a purpose and a proper legal ground. So on the other hand, we have the AML law stating the purpose and stating the legal ground. Yes, so everything, this processing takes place both according to the GDPR regulation and also according to the AML law. Another example that was also mentioned today, the data minimization principle stated in the GDPR. So it says that for the particular purpose, you can process only the data that is adequate, relevant, and limited to what is necessary. But the AML law and the FSA's normative regulations prescribe some standard of data amount that needs to be processed. And of course, the situations of our clients are very different. So the law will never be 100% exhaustive, precise. So there might be situations that the amount of data needs to be assessed on a case-by-case basis. But this is not a standard situation, because let's clarify that the vast majority of clients have very standard situations, have very simple situations. And now I speak about, let's say, around 95% of clients, yeah, which is really the vast majority. Maybe even those percentage is even higher, yeah. So only in even less than 5% of cases, the clients are undergoing the enhanced due diligence process, where some additional data is being obtained. But also in these cases, the main information, the main data and documents are coming from the clients. Clients are providing their data, are providing explanations, and according to the AML law, banks are just verifying, are checking if this provided data is correct. And therefore, some additional checks may be carried out to fulfill this legal requirement. And of course, the banks also have their internal procedures, their internal control systems. They are training their AML specialists and actually all employees on different aspects. Also, for example, the GDPR trainings are mandatory for absolutely all the staff. And starting from the next year, there are going to be even more AML/GDPR trainings according to the new amendments in the AML law. And during the past months, the Finance Latvia Association have had consultations with both the Financial Supervisory Authority and the Data State Inspectorate about the content of those trainings. So, and also, as Laima Letting mentioned in her presentation, both regulators are also very hardworking in cooperation with the Finance Latvia Association on the upcoming GDPR AML regulations that are going to be part of the FSA's normative regulations, and they will clarify exactly what you have asked in your question, those aspects of interaction between the GDPR and AML. So let's say, stay tuned and you will learn much more in the upcoming future. Thank you.
All right, and Raimondas, what's your say on this?
I would probably agree with my colleague, but I wanted to add that because of the slight different regulation between member states, we can have a little bit unclear situation when we are working in this field. Because I said previously, in Lithuanian law, we have some kind of wording in law that allows us to use more data, and it's like permitted. And in this case, we even have quite a big impact from MAL regulators to go beyond what is necessary, and just to have a zero approach. So in this case, I have even example when we're doing KYC procedures, and particularly the checklist that is sent from the banks to the clients, we have quite different questionnaires between the banks who are working in the same manner. Okay, it could be different risk management approach, but if we're talking just know your client aspect of the ML measures, it's not really a good approach. So we're contacted now with our banking association and trying to find solution how to standardize that approach, how much data is really needed for one or other measure if there are same risks levels. So probably we have to have standardization, because in the field, when each party decides on their on the categories of data which are needed, it's not really a good approach. So I'm looking forward for more regulation in that field.
All right, thank you. Yeah, well, more regulation sounds on one hand appealing, on the other hand a bit scary, but yeah, there are some arguments, I believe. Yanis, I have a question to you. Let's use the opportunity that I'm not from your industry. I mean, in general, from this topic, data protection and all the contents that we discussed today. How is this happening? Because I believe that, say, banks, they use your services and you sell them or give them ready set data packages. And it might be the case that they get within the package more than they actually need for that particular procedure. Is that so or not so much? So can you comment on this process, explaining, because I believe, and we have more than 700 people actually connected today in this conference, quite a bunch of people. So I believe not all of us know this process that well.
Yes, thank you for the question. And I think to start my answer, I want to do some justice to the company you mentioned at the beginning. You gave an example of Refinitiv WorldCheck as one of the international data providers. However, I should say that if we don't mention other companies that we work with in searching worldwide for the data that we need, that our clients need, then it would be as if we are talking about the mobile phones and saying that there's only one manufacturer, iPhone, or only one mobile phone. So I want to emphasize that there are many international businesses that work in the data fields alongside Creditinfo, such as Dow Jones, LexisNexis, Acuity, Bureau van Dijk, Swift. And those are just the biggest names in the industry. And these are companies that employ thousands and thousands of people worldwide to help banks and other obliged entities to navigate the maze of regulations on a country-by-country basis, or even state-by-state basis, to collect the information worldwide to allow banks and other obliged entities in compliance with IML CTF regulations. Now, back to your question, the data packages that we provide are actually very detailed, very granular. Even the WorldCheck database that you mentioned from Refinitiv, it's just one of more than 100 products that Refinitiv is offering to data users. And all this data is, each data bit is for a specific purpose, be it identification or finding out the sources of wealth. And it's very granular. So it's up to the end user of the data to decide which bit of data he needs for which specific stage of the KYC procedure. and all we do is provide the data that the end user needs.
Okay. Maybe a stupid question. Can I, as an individual, address your company and ask to provide everything you have on me?
Yes, of course.
Because why I'm asking is that Latvian legal act on prevention of money laundering foresees restrictions on data subject rights, for example, such as right to access. And I've heard examples from my friends actually that their bank just closes the bank account without any explanation. Just like, this is what we do now, and you have to live with it onwards. So, on the other hand, the right to access is considered the cornerstone right for data subjects' control over their data. So, if you don't know what is being processed, you cannot effectively exercise on those other rights, such as correction, deletion, etc. I'm not sure who to address this question, but what are the considerations on exercising data subjects' rights in the AML field? I mean, it's.
I can start with a few known examples.
Okay.
In Europe, where suspicious activity reports filed by financial entities with financial investigative unit have been challenged by private individuals because the reasoning is that their accounts have been closed unjustly, but they cannot challenge this in court because they don't have access to information and they cannot challenge this information. So this is an area where European countries are still working out a procedure to balance the proportionality with the right of intervention in data processing, and different countries are looking for different solutions. Some countries are allowing individuals to challenge this in court. Other countries provide indirect access through data protection authority, but it's still very much a work in progress. Thank you.
All right. I see two hands. Veronica, let's start with you.
Thank you. I will rather start with the very beginning with the GDPR, because GDPR states that the right to the protection of personal data is not absolute. So it is allowed at particular circumstances, at particular conditions, to limit those rights. And those circumstances, those conditions need to be mentioned in the European Union or in the national legal acts. So also in Latvia, our AML law and also what we call the GDPR law provide the possibility to limit the data subject rights in case the data is being processed for the AML purposes. And then the next question goes, if those limitations are necessary and if those are proportionate. And we can prove that they indeed are, because first of all, if the data subject would access his AML data, that could seriously jeopardize the fulfillment of AML law purposes and create obstacles in the due diligence procedures. For example, if the data subject knows the methods, the principles implemented by the particular bank, and learns which situations are considered to be suspicious and later on reported to the competent authorities, he would, of course, next time act in a different way so that nobody can catch him. It's like when you're knowing where the video surveillance cameras are located, so you precisely know how to plan your path in a different way. And secondly, so another consideration could be that the AML law prohibits tipping off, and we talked about that today already. Basically, what does it mean? It means that it is prohibited to inform or to warn the person that information about him, about his transaction, was reported to the competent authorities as suspicious. Because again, if the person is warned, it can create some obstacles in the investigation or litigation. So you mentioned that the person cannot access its data, but in the AML area, for the AML purposes, as I already mentioned, the main data, the most part of the data we receive exactly from the client. Yeah, so the client already is informed about the vast majority of the data that is being processed for the AML purposes. What banks do in addition, we just check if the provided data is correct. Thank you.
All right, a few more hands. Laima, please.
Well, fully agree to Veronica. Just really short remark to add. Here in Latvia, we have discussed a lot about receiving of information from financial institutions in case when account is closed or there are certain problems to open an account or continue the using of an account. But at the moment, I would say that a solution already in practice works. It is found in cooperation between the supervisors as an intermediaries in those specific cases where, of course, SORD, regulator in AML CFT field, Financial Capital and Market Commission have an authority to receive all client files and see whether the information included there is related to anti-money laundering or not, and whether the data included there is precise and processed correctly. And in those cases, they can work as an intermediaries between the client and between the bank, and few processes have taken their success already this year. The same works in the cases when we are talking about another area. It's basic account availability, and it's under Consumer Right Protection Authority. Also in these cases, the Consumer Right Protection Authority doesn't have any authority to receive client information from bank which is related to anti-money laundering issues, but in these cases, the authority of consumer rights can work together with Financial Capital and Market Commission and find out whether we are really talking about anti-money laundering cases. And just to confirm and support, really, it is unnecessary and it can compromise the further inspections in cases when information is disclosed to the client. And that's why Finance Latvia Association already last year speak about that we need to move forward to the situation where the most data isn't processed and received from the client, but are received from registries, from state authorities, etc. And in these cases, client isn't involved in the process, and if it works positively in both ways. In the cases when client really is a criminal, he doesn't know that he is being supervised from bank side, from police side, etc. And in the case when he's not involved in any criminal activities, he doesn't feel that administrative burden from bank side, and he doesn't need to work a lot on his documentation, etc. But it is a really long shot and a really long way to go to this specific situation. Yeah, thank you.
All right, thanks. Just coming back to what you said in the first part of your comment. So in cases I'm rejected by the bank, I don't know, in the beginning or in the process, I can then address my concerns to the authorities and expect that they would explain, instead of the bank, the authorities would explain the reasoning behind bank's decision. Is that so?
It would depend on the situation, but the supervisory authority is the one who can intermediate this case without, without putting on a stage and on a stake the whole investigative process in the case if there is one, because bank in a lot of situations wouldn't be able to respond very precisely about the situation in bank. Of course, the answer to client is needed, and it's also one of the topics we are working on under Financial and Capital Market Commission guidelines to explain what is the limit of information that can be provided to client and what is the limit of information that cannot be disclosed in any cases. And we are trying to find this balance to explain also to clients why. But I can already mention that most of the cases we have heard here in Finance Latvia Association is the cases where client doesn't submit the information needed for KYC processes, and of course it is the reason why a bank account isn't opened or it is closed during the activities. If you doesn't submit the information, it is the main reason why, because banks have an obligation in these cases to react, and they cannot continue in any cases their cooperation.
I see. Personally, I know 3 cases, 2 individuals and 1 company that had have been rejected by the bank. But interestingly enough, 2 of these cases ended up the company and the individual, they continued their operations in Latvia just with a different bank. And then you have this weird sensation that, oh, this bank is more strict, but then you go to that bank B or C or D, whatever it is, and they would accept you. And isn't it a bit weird that do you have any explanation how can it be so?
I can explain very fastly. It's because each and every bank has its own risk profile. It means that there is a risk appetite in each bank, and if the client's risk level is above the risk limit of the bank cannot take him as a client. It's normal. It's nothing special, and it's even not related with any like criminal activities, etc. It only means that the bank doesn't have a risk management procedures or tools in place to manage the exact client risk.
I see.
That's all there's.
Thank you for the explanation. Raimondas, your hand is raised a long time already.
Yeah, I also would like to make some amendments to what already have been said. First of all, in Lithuania, we haven't this kind of restriction to the access. But when we are looking at the actors who are working in the system, we see that there are private entities and also public bodies. Some of these public bodies who are working in the whole ML system also are competent authorities under law enforcement directive. And that directive and transposition in Lithuanian law, it says that access to some of the data, but in those competent authorities, couldn't be accessed, or access could be limited. But there are some kind of legal grounds for that. And one of them that is probably used and in ML cases is when the access to that data could impact the criminal proceedings, criminal investigation proceedings. So in this case, we have the limitation of the access to the data. And also we have to note when the criminal investigation code is applied, also those institutions have the right even to give recommendation that are obligatory for even private sectors to not give access to the data, because the access could be harmful for that investigation. So the system is a little bit different, and we have also the possibility to limit access, but not like general limitation in the case. So probably that's all what I wanted to add.
I see. I'm actually checking currently the comments section on the conference's platform, and Veronica, you have a comment there. I will not read it, but you can just enter the platform and read the comment by Andres. It is, I think, related to what you said, an example about the surveillance cameras, and if you know where they are, you would choose the different path and probably hide your face in some more risky zones. And probably it is the case that at least some of the users and customers already know where the surveillance cameras are and what they are looking at. My next question is, it's related to what we have discussed so far, but let's imagine a situation. Say a data subject has suspicions that the AML subject has used incorrect data about data subject in the customer investigation, and how can the data subject then take action to correct the wrong data? Let's start with Yanis. I believe you had cases like this. I don't know, but I believe so.
That depends on the country.
Let's talk about our country.
Well, I think we already discussed this case, and this is so-called indirect approach, where you can address the regulator of a particular obliged industry. In case of banks, it's Financial Supervisory Authority. In case of micro lenders or consumer lenders, it's Consumer Rights Protection Agency. And for other obliged entities, it's State Revenue Service. So I guess the banks are most frequent object of customer dissatisfaction. So indirect approach would be to FSA. Correct me if I'm wrong, Laima.
Yes.
You're right.
You're right. Very short. You're right. Yeah, well, obviously, the end users would then, if, for example, rejected by the bank, be not satisfied with that particular bank and probably complain to them, not to the data sources that they probably not that aware of, I would say. Okay, I see Veronica has a comment.
Yeah, just a very short comment that I already mentioned that the most part of the data we're receiving exactly and directly from the client. Yeah, data, documents, explanations. And therefore now to say that, you know, we're facing some catastrophic errors in those data, no, I would say that theoretically, of course, some errors are possible, but the probability still is very low. And the client himself knows already very well what kind of data is being processed and whether they are correct or not. I would say that rather this situation is a bit adverse because the AML law imposes an obligation on the banks to check if the data provided by the clients is correct. So, you know, this right to process the correct data is entirely on the bank side. Yeah, we are afraid that the client might have not provided correct data or full data. So we also have some rights and even obligations in that context. And as we already discussed, so basically, if some data subject rights are limited, that doesn't affect the right to turn to the supervisory authority with a request. And I hope that you understood everything very, very well and in a correct way, that in distinction from some other standard situations that can occur with the controllers in other area, in the AML area, in the banking sector, we are facing not one supervisory authority, but two. Yeah, therefore, the situation is so complex that the supervision of the compliance to the GDPR is entrusted to the Data State Inspectorate, but the supervision and monitoring of fulfilling requirements deriving from the AML law goes to the Financial Supervisory Authority. And therefore, it is crucial that those both authorities cooperate between each other and also agree on the borderline where their competencies meet. Thank you.
All right. I'm just thinking now about the magnitude of the issues that we're discussing here. Can you guys provide me, and to all the viewers, of course, some sort of statistics, I would say, and because the KYC procedures are applied to all customers. What's the proportion? What's the percentage? How many fail or to go through this filter. Do we have such data to offer today?
No, very short answer from me, but I can give one more statistics that none of the complaints submitted to Financial Capital and Market Commission turned out to be really a case.
So there was no grounding?
It's about, no grounding. And there was always banks in all cases were the ones who were acting in accordance with the law. Therefore, I would say that these cases are rather more connected with just
emotions.
Emotions, also with cases where client really doesn't want to submit and disclose the information and he feels threatened. In some cases, it's on real grounds. In some cases, it's just emotions. But bank procedures in recent years have made one of the biggest evolutions here in Latvia in all European Union. Therefore, I would say that they are precise as a clock. Good Swiss clock. Yeah.
Could you please elaborate on our achievements if compared to other European countries?
Well, to compare, we see that the new European Union AML CFT package offered by European Commission more or less reflects what Latvia has already achieved in this area. When we went through all the Moneyval and FITF requirements, we really did a great job, and right now we are the only one country in the world who have reached the compliant or largely compliant, large compliance with all FITF technical requirements. It means that our legislation reaches the highest level of the requirements. If we are talking about the practice, what we also saw last year, that the requirements for individuals and enterprises were really very strict, and this year we moved forward to elaborate more on this risk-based approach, and I think that we already see the fruits from this process without losing any goals of the strict rules. We now are able to perform them more reasonable with regard to our clients. Yes.
Right. So it's interesting to hear that Latvia is a sort of a superstar globally on the world's stage. Raimondas, you are from Lithuania. Would you agree with this statement?
I just want to mention one point that was in the EDPB Wojciech's organization opinion as relates to the full package of amendments related with the ML directive. So I didn't know exact numbers about problems that are raised with data processing, but what was mentioned, it's an increasing number of false positives that are noticed to the FEI use. And this means false positives that very harmful impact is made to the client or data subject. And it is also a call to have a better system how this process should be implemented and what risk-based methodology should be used, because when even in that area, when we receive a lot of different information and personal data, we still have a lot of false notifications to the financial intelligence units. And this means that the system is not really good one, and we have still a lot of steps to improvement. So just one aspect that I wanted to touch.
And what about Lithuania's position in this global ranking that was just invented and Latvia being on top of it?
You know, I'm not from banking supervisory authority. I'm not from banking sector. I'm a supervisory authority, but I couldn't say, because I know that we are Lithuanian bank, National Bank is also one of those who don't tolerate money laundering issues and have approach of zero tolerance approach. So I would say that that's why I'm here and we are talking, because it's quite an issue from the perspective of data protection.
Yeah, well, anyways, come over. It's just 4 hours drive, and we'll teach. You know, okay, just fun here. Although another fun fact is sometimes when I see people that try to hide things, they open bank accounts in Lithuania and invoice me with those bank accounts, and I'm always like, well, sort of very close. And then again, there are some loopholes probably there where you could get through. Right. My last general question in this panel discussion is as follows. So you know your customer procedures are applied to all customers. And so do you consider it proportional to investigate everybody just to weed out the few that are actually suspicious and maybe guilty? So because usually the best data protection practice works in the other way around. There should be procedures in place to identify suspicious activity and only then dedicate extra effort to investigate those very few and not to investigate everybody. So can the due diligence be carried out without invading everybody's private life, both for existing and potential clients? So what do you think? It's a large question, I know, but we have some time left so we can discuss this. Who wants to start?
I can start probably because I already touched this issue in my presentation. Well, here's the pain of the AML CFT area as a whole, because you cannot know whether you need to investigate, not investigate, but to make a certain due diligence measures in case if you don't know the information about the client. You can know how deep you need to dig only if you find certain first information about the client. For example, the words we all know, politically exposed person. For example, you need to know whether your client is or is not politically exposed person to know what further information pieces you need to gather. That's how AML CFT system works. Of course, it's painful for GDPR issues, but I think it doesn't contradict with GDPR rules, as you need to evaluate the volume and the depth of the information you need to gather in the first stage, and afterwards you need to evaluate whether you need to dig deeper. And as far as it is in connection with the aim, with the purpose of the data processing, to know your client, to know what are the risks of your client, and to know how to act in further cooperation with the client, I think it doesn't make any disputes between the GDPR and AML areas. If, of course, you haven't evaluated the level of the client's risks and you are just digging all information you can without any reasons, it of course will be over processing, and you need to reevaluate your processes in the credit institution. But if you are acting in accordance with GDPR rules, there is nothing to worry about. I would say like that.
Okay, Jānis.
Yes, I would add that excessive data processing usually happens in an environment where both the regulator and the company is focusing on box ticking, as it's called, rather than on the essence of the regulation, which is to screen the customer, do some basic due diligence, and if there are no red flags raised, you shouldn't be doing anything further. Whenever you go into box ticking exercise, this usually results in what our colleague from Lithuania mentioned, false positives, that just to be on a safe side, the regulated entities overwhelm the regulators with suspicious activity reports just to be on the safe side, just to tick the box. So rather than ticking the box, we should learn, or rather the regulators and the companies subject to IML should learn to see 50 shades of gray instead of just black and white. And in IML CTF context, this is called risk-based approach.
Do you consider this as a problem of lack of knowledge, or is it just a mentality to be on the safe side? I don't know, our legacy from Soviet Union or post-Soviet Union way of thinking.
No. This has nothing to do with post-Soviet Union and our legacy. Box ticking is the easiest thing to do. So if regulator allows it, and if this becomes an accepted behavior on part of the regulated companies, then they always will try to make the regulation as specific as possible to end up in ticking the box.
Right. So you're saying this is taking
this is
a path of
common problem that is both in old Europe and East Europe. It's nothing specific to
so it's
Soviet.
basically taking a path of less resistance, like
Exactly.
easier thing. Raimondas, I really want to hear your comment on this.
Yeah, I wanted to raise my hand, but probably I agree with my colleagues because it all depends on risk-based approach and risk management system. And I would like to add a very interesting note from one of Advocate General from the recent SCGU judgments and cases. He said that we have to bear in mind ex ante and ex post investigation. This means that if we are making ex ante before our relationship, some kind of checks and something, we can have a system which allows us to make the checks from whole clients, whole customers, but the amount of data should be as much as minimal as needed. And when we have some kind of flags, when we see, this means it's some kind of risk with that particular client or customer or data subject, then we can make exposed investigation. And that exposed means that you're using just this one person's data, but the amount should be that amount that is necessary to achieve that investigation, to have a proper answer. Is it safe to make some kind of transaction or not? So I would say that risk-based approach and different steps at your investigation could allow more or less data and more or less clients that should be investigated in particular case.
All right. Any other comments from panelists on this?
I just love that we are all using the name investigation, but we are speaking about the private sector and due diligence measures. The investigation is more or less in other institutions, but it just raises the thing I already noticed in presentation regarding that we need to understand the level of obligations which are put on the banking sector and other sectors under those AML CFT requirements, and understand them in the regulation too, that it's quite hard work to do and without any public authority possibilities. Yeah, thank you.
All right. Free microphone here, if you will. Yes, Veronica.
I understand that you're expecting some comments also from my side, but I just think that my colleagues already provided the main conclusions. And I can add that actually the question that you asked, or rather the solution that you provided, is already the reality. Because as I mentioned, those enhanced due diligence procedures are taking place in quite rare cases, because the vast majority of clients have very standard and very simple cases. And also, I fully agree to what was mentioned by my colleagues, that this is a risk-based approach that has been introduced both in the GDPR and in the AML, that needs to be taken into account. And as we already today discussed, it is extremely important that the supervisors, because in the end of the day, these are the supervisors that could come and audit the carried out due diligence activities and conclude that most probably the data amount wasn't enough, or that not all the risks associated with the client were identified. Yeah, so the ticking the box, I think, is being done not because this is the easiest solution, but because you have to show your homework to the supervisory authority, and they are, in the end of the day, who assess how you have fulfilled your homework, and in case that wasn't sufficient, that was in violation with the applicable regulation, then also quite significant sanctions can be applied both in the AML area and in the GDPR. And therefore, it is extremely important that the supervisory authorities inform about their expectations, and that they closely cooperate with the sector that they are supervising. And I think that Latvia can be very proud not only of achieving those highest standards in the AML area, but also, as we mentioned today, that cooperation between both supervisory authorities and the financial sector. Thank you.
Thank you. Looking at the clock, I think it's time now to wrap up, and I would like to give floor to everybody to, since our conference theme is future perspectives and personal data, why don't we step in a crystal ball and look into, say, 5 years future, and let's assume that we have achieved all the wildest dreams and ambitions, and this field that we are covering today. So what do you think? Where are we at, or where should we be at? Laima, let's start with you.
From my perspective, I would love, regarding ML CFT field, to see that more or less data regarding KYC procedures are processed from the databases without putting any administrative burden on the clients, that we are in close cooperation with all state institutions, police, FIU, under our public-private partnership, which is put on in another technical level, and all clients can expect the best services from the bank without any interruptions. And from the other side, the ones who want to use financial system for money laundering, for financial crime, they are just put away in a fast and non-way back manner. Yeah, that's future from my perspective. Thank you.
Jānis?
Yes, well, not disputing what Veronica said, that enhanced due diligence is not applied to many clients. I would like to emphasize that we are part of the global economy, not just we as Latvia, but European Union. We're part of global supply chains. So to manage the risk, to apply risk-based approach, international data companies like mine have a role to play, and they will continue to help businesses to verify the data against international databases from across the world. Thank you.
All right, Veronica.
Yes, thank you. I think that you asked a very challenging question because, especially if we are looking from the COVID perspective, yes, then let's have a look what it did to our private life, to our work life, just in one day. Yeah, so definitely in the future there could be some unpredictable challenges that we need to take. Also, let's not forget that this is not only the GDPR that is applicable, this is not only the AML regulation that is applicable, there are many more other regulations. As I mentioned, the banking sector is one of the most regulated sectors. So I hope that in the upcoming future, more clarity would be put in order to harmonize all those regulations, in order to make application of those regulations in a smooth way. All of those regulations have their own competent authorities, so also some efforts needs to be put in order to harmonize a cooperation between those competent authorities, so that the subjects to those regulations like banks and also the data subjects like our clients are not suffering from them, but that they are benefiting in the best way. Thank you.
Thank you. I've noticed that Raimondas was taking notes, I think, and so you have your final conclusions as well.
I wanted to paint my future and what I imagine, but probably I'll say with one particular sentence that I want to have in the future. So in my case, I would like to look in the future and see the significantly decreased number of false positives, and that also means that the negative impact for the customers would occur just then when the background is, and it wouldn't be that the clients, the customers, or data subjects wouldn't have unnecessary impact to their life.
All right, with this, thank you all the panelists for actively participating and being keen to provide your comments and answers. Thank you so much. Nu ko, draugi, mēs turpinām.
Thank you, dear friends. We say goodbye to our panelists who were very helpful as far as they could. They were also open and shared their professional and personal vision on the topic. Looking at the program of this event, we do see that right now it is a time for a break for a whole hour. We will resume at 1:30. Before that, one thing to mention, I believe that many who follow this conference are making notes, either in notepads or electronically. In this building, actually, we have an artist, Dace Andersson, and she has actually noted this discussion from her point of view. See how she sees all of it. A lot of things to scruple. In pink, what is in blue. It is actually very, very interesting. We should and we could publish it somewhere, although I do not have it written in a scenario, but I don't think we will reveal any personal data if we were to publish this. So far, a mixture or a visualization of this is important subject being displayed in an arts way. And the second part will be dedicated to sending data outside of EU, rules and risks connected with it. Let us resume in an hour. So, bon appétit.
Esiet sveicināti atpakaļ.
Welcome you all back in the Conference of Data State Inspectorate Personal Data Future Perspective. I hope you had a good rest and had some coffee or had some lunch. We continue with our program, and on this Alpha stage, by saying Alpha, I want to stress that we have 5 stages. If you joined the event just now, then probably you notice on top of the screen there are 5 blue buttons, Alpha, Beta, Gamma, and according to the program, you can choose the content and the place to be. Also, you can switch languages on the bottom right-hand side corner. You can see a symbol of headphones, and by clicking on it, you can choose between Latvian and English. Also, you can see a comment or chat part on the right-hand side of the screen. I am going to comment as well on different topics. Also, there are several surveys with a letter I, and underneath this icon, you can respond to the question. And at the moment, the topic of the questionnaire is whether you consider your data is safe. And all have answered no. Unfortunately, I don't see how many are there of our respondents. So we start our second part dedicated to transmitting data outside EU, and we are going to talk about risks and rules. And we will have several speakers who will afterwards join each other for panel discussion. You can think of your questions. And during this panel discussion, I will read these questions and be inspired. So I will ask them, hopefully, to the speakers. So let us start this part. Our speaker is Julia Teruhina. She's a lawyer in Sorainen law office. She's also a data specialist, and she ensures compliance with GDPR to big companies. Please, Julia Terjuhina, at the top of her presentation, SREM 2 decision, and namely the case law and how it impacts transmitting the data to third parties. Thank you very much. I am very glad to be here. I'm trying to share my presentation. We already in the morning considered the Zoom has a subtitle of being technical problems. If you cannot solve them, we can put the presentation for you. Unfortunately, there is no possibility for me to share the screen. I'm looking at our support personnel. Are we ready to share Julia's screen? Yes, so we will put it on, and you can just say next slide. Thank you very much. Next slide. Initially, today, taking part here as the first speaker, I'm going to talk about how it is important to talk about transmitting data to countries outside EU and EEZ. Let's remember that even before GDPR regulation and directive, there was a specific order for transmitting data to the third countries. And now you can see the articles stating or stipulating what security measures should be taken when transmitting data to third countries. It can be in different situations when data is being sent within the same company to daughter companies, or when you are sending data as data manager or sharing as data managers, or you are for example, hired to process data. Also, how to do it between persons if you are neither data managers nor data processors, or if you are data receivers, international organizations. Next slide, please. Let's have a look at the map. We understand that data protection level all around the world is not the same. It's not strong enough everywhere. We have been used living in this bubble of data protection within EU, and we think that nothing can happen with our data. And if something happens, then we might say, who is interested in data about me? This is a very popular opinion. But let's remember that there are different countries around the world with different regimes in them. Countries that have given powers to their law enforcement agencies to manage the data, to use the data, as well as take decisions, binding decisions based on these data. This is a screenshot from CNIL, French organization. Dark blue depicts those countries who provide adequate data protection level: European Union, European Economic Zone. There are countries having some data regulation, and some countries who are colored in gray, having no data protection at all. Also, there are countries that are light blue, or for example, USA, we are going to talk about today. Also, countries ensuring sufficient data protection. And let's talk what happened and why there is this division. Next slide. Within the EU, free data flow is a part of business world, also the success story of the EU. By ensuring adequate protection, EU allows for free data flow, meaning that service providers can provide their services to users, consumers in other countries without thinking whether some additional measures should be taken for data protection. But this is not the case when speaking about third countries. If we are dealing with third countries, additional measures should be taken, provided in regulation, ensured in order to ensure adequate data protection. Next slide, please. What have we had until now with USA? Next slide. In USA case, already from 1998 until 2015, we had a regime called Safe Harbor. And it ensured order how data should be transferred to USA. Later, when in 2015, the Court of the European Union took a decision, C-362, lifting safe harbor regime. Another decision was taken, namely that between USA and EU, parts of the world having a lot of data flow, also taking into account that a lot of service providers for the EU are being located in USA, all kinds of service providers like cloud service providers, social networks, IT providers, having monopoly status. They mainly are located in the USA. We all use those service providers on a daily basis. That's why a new regulation, new order was established, namely Privacy Shield, providing for very stringent rules how data should be processed, how those different players exchange data. And here you can see what measures were taken in order to take part in Privacy Shield program. Amongst others, there was a ombuds mechanism, an arbitration mechanism established, as well as a mechanism for updating Privacy Shield program and evaluating whether this mechanism is still safe and up to date. What happened next? In 2020, EU court took a decision again declaring Privacy Shield void, thus making all the data exchange that were based on Privacy Shield unlawful. What to do? So those processes of sharing data should be based on another mechanism foreseen by the regulation, because as we can see, Articles 69 and 46 and 49 foresee how it can be done, and we are going to talk about that. In addition, the court established the following: that the standard clauses that data exchange were based on cannot stay in force in USA because they do not ensure adequate level of protection. And the period of uncertainty followed because there was not clarity how to proceed. What happened next? In summer of 2020, the College of European Data Protection announced, or actually issued, guidelines 1/2020. You cannot see it on this slide, but you can note it down. In these guidelines, Data Protection College analyzed how to live after the case law of the European Court of Justice, and analyzed how we can base ourselves on exchange of data procedures prescribed by Article 46, and what additional safety measures should be taken, technical, organizational, or based on agreements. And based on those decisions, if data is transmitted or received from USA, the college said that all agreements should be re-signed or readmitted into until 2022. These standard clauses shouldn't have to be entered into immediately. Now it is an interim period, whether the person or legal person is going to enter into a new agreement. But anyway, all the data managers had to re-evaluate their risks and make the risk assessments. Now the burden is put on even more on the shoulders of data managers. Beforehand, just a procedure of registrations had to be done, and supervisory authority was the one deciding and filtering both parties. Now, all the tasks have to be done by the managers themselves, by the data exchange officers themselves. This thing cannot be forgotten. This is not just a theoretical thing, because unlawful transmission of data to third parties can be fined. Speaking about ensuring data protection, exchange of data, and more about how a new standard clause works and how one should do the evaluation of the lawfulness of data exchange, and the next speaker is going to talk about, but I would like to draw your attention to the following. What the College of European Data Protection noted: if we differ from or deviate from standard clauses, how we can live if standard clauses are not in force. Article 49 of the regulation foresees exceptional cases. During this interim data transfer impact time, when standard clause is no longer in force, we have to evaluate whether exchange of data is permanent or not. Namely, if exchange of data has a uniqueness or one time only, we can get an assent from the data subject. And in that case, we can base ourselves on the exception of Article 49 and transfer the data to USA in that way, or based on that principle, as well as if there is an interest, that is for the interest of the society. If necessary to prepare for an agreement, or prepare an agreement, or prepare or transfer the data that is publicly available on different registers, or if you are doing the preparatory work for future cooperation, then you can do it and decide that it is an exception. But my suggestion for you is to read the original regulation on the Article 49 to the full extent, with all the exceptions and implementation described in Articles 45 and 46, because everything is there, and what should be there is all prescribed by Article 49. If none of the mentioned in the regulation is possible, then I would like you to have a look at Article 46 on the previous slide, and let's have a look at what can we do. In that case, we can either re-enter into standard clauses, or we can amend binding agreement between companies. This is time-consuming process when this is necessary, when data should be transferred to other companies within one company. Also, we can register rules of procedure, as well as we can register mechanism, or this can be an ad hoc, unique agreement apart from standard clauses, where in a detailed manner, all transfer of data is being described, foreseeing also all the guarantees in order to ensure data protection when sending data to USA or another third country. What is not being said in my presentation that you have, but I wanted to mention, are the following. Also connected with Article 46. And also mentioned in guidelines of European Data Protection College, guidelines number 1/2020, how we should fulfill our obligation of re-evaluation that should be done by data managers. It is all described by Article 46. In this situation, when standard clauses are void, and most probably we will enter in standard clauses number 2 or another tool from Article 46. We have to clearly define and document what the data processing procedures exist in our enterprise, in our practice. What is happening when we submit data to a third country? What documentation is relevant and should be filled when transferring data to a third country? Also, we have to evaluate and understand risks connected with a third country, which can threaten good processing of data. It might be requests from law enforcement agencies when, for example, an enterprise has an obligation to reveal personal data, something that could not have happened in the EU, but that could happen in the third country, or safe keeping of data in secure servers, and taking into account neighboring countries, as well as additional measures should be evaluated. Additional measures apart from those mentioned in Article 46. It might be another article in agreement between two parties. For example, additional encryption or something in addition to ensure this security. And the last step, when we have done the evaluation, we have to remember that this is not a one-type event, one-time measure. We have to regularly amend and look at all the requirements connected to data protection. We have to update our knowledge and be sure that case law shown 2 doesn't apply to us. So life after. Life after, we will see you, Julia, in a short while. But now let's tackle the next topic. Again, exchange of data, impact assessment, and standard clauses. And we will give the floor to Anna Vladimirova Klyukova. She is a lawyer, certified data protection specialist in the questions of cybersecurity and data protection. So, Anna, are our data safe?
Hello, good afternoon to everyone. I hope that our data will be safe, and we will discuss these matters during our panel discussion. Yuli already mentioned this, and we will look at the exchange of data with third countries as well. Today I will continue what Yuli already started, and my presentation will be devoted to a more accurate and more on a narrow topic on standard clauses and impact assessment aspects. I will deliver my presentation in Latvian, but the slides will be in either language. So I will tell in detail about the new standard clauses and what are the most important nuances. Julie already mentioned that by the end of 2022, everyone should have the new standard clauses, but what else is important in this regard? If you have standard clauses in an agreement and you haven't had them before, but now you would like to use this mechanism, would like to use these standard clauses, if you sign an agreement now in 2022, you would still have to sign a new agreement if you have used the old standard clauses. Also, if you have an agreement with old standard clauses, but you would like to amend these standard clauses, like, for example, the data volume change or the types of data or security mechanisms, or another party is added to the standard clauses, though it happens before 2022, end of 2022, you will still have to sign new standard clauses. And this has to be taken into account. Maybe it's worth waiting until 2022, and then you can use this new opportunity. But if you have to amend now, then unfortunately you will have to sign yet again the agreement. Next slide, please. Another important nuance what concerns new standard clauses while we wait for December 27, which is right after the holidays. And then there is also a question if we have to adopt the new standard clauses. The answer to this question is we have to do that because we have more extensive choice, because we used to have 2 options, but now we have 4 options depending on our cooperation model with a third-party data recipient from another country. So you have 4 choices between 2 processors and 2 controllers. So it can be controller-controller, controller-processor, processor-processor, and processor-controller. For example, if in the third module, if you have a sub-processor in the US and you are a processor yourself, then you can use module 3. And the third would include you would be acting as a processor in the EU, but the controller actually is in another country. Other important aspects that are worth discussing are as follows. Unfortunately, I said that you will have to sign new standard clauses. Earlier, data exporters had a duty to make sure that the data will be safe, but actually, legally, transferors rely more on standard clauses. They are included in the agreements. The agreements are signed. The scope of data transfer is described, and that's it. And everything is fine, and no one cares for anything else. And that's why the standard clauses were very popular. But now, of course, the standard clauses will continue to exist. And after the Court of Justice judgment, and we see now that more extensive assessment will have to be performed, also on the basis, on the guidelines of the European Data Protection College, described by Julia. And also you will have to prove that the data will be safe and that the protection level will be similar to the level ensured in the European Union. As to the convenience, standard clauses can be signed by more than 2 parties, namely 3, 4, or more parties. If we speak about the fact that the agreement is signed between the controller and processor, Article 28 of the GDPR is already included, or the requirements of this article is included in the standard clauses. But if you want to add something else, if it does not, if it doesn't violate the purpose and the meaning of the clauses, you can add this additional information. Also, in addition, you will have to describe in detail the security measures that the parties that will be agreed by the parties to ensure that the data are safe. And Julie already touched upon them, but I will also explain them. And this relates to the impact assessment. That is a comparatively new requirement. I can't really say that it is totally new in the data protection world, but in the context of data transfer, it's a bit shocking. But I will tell how it can be done and what are the basic requirements, considering time constraints. And of course, one guiding principle regulates all of these activities, namely accountability principle. Namely, the person who transfers the data should be able to prove that everything possible and needed has been done to ensure that the data are protected in the third country as well. And here it is important to take into account the fact that the right to data protection is not a passive right that should be protected. When a data subject approaches you and complains about something, like the rights being violated. These are actually positive rights. So if you have data, including the state, you have to protect these data actively without waiting for any violations. As Julie already mentioned, and I will reiterate what she said, actually, at the beginning, we assess whether the receiving country is safe and compliant with EU requirements. Then we choose a mechanism of transfer. And one of these mechanisms could be standard clauses or any mechanisms described by Julia. But we also have to engage in continuous monitoring and assessment to make sure that the situation is still compliant, because circumstances can rapidly change, as well as laws in other countries, and then suddenly our impact assessment is not valid anymore, and we will have to adjust the transfer conditions to these new circumstances. What are the main sources of information? Of course, Commission decision on new standard clauses that describes several measures that apply to transfer of data. And then, of course, the EDPB's recommendations number 1/2020, and also guidelines or recommendations 02/2020 that lay down requirements, recommendations, and ways how to assess if the receiving country is safe from the point of view of monitoring. Because one of the main problems was that actually various state bodies could quite significantly interfere with fundamental rights and so on. And these two recommendations should be taken into account. So what should be assessed? And how can we understand if the country to which we want to send the data is actually compliant with GDPR and these recommendations? First, we need to take into account the context of processing of data. So what is the transfer chain? How many players are involved? How many parties are involved? Of course, the longer the chain, the more risks are present. the more protection measures are necessary. Also, what are the purposes? Also, what are data categories? For example, if we speak about special personal data, sensitive data like health data, which is very topical nowadays. So maybe we will need stricter guarantees here. Also, we have to look at the place of storage, and then also the economic sector. Maybe these are national measures or national services or marketing services. Maybe it is a financial sector where special laws are enforced that should be taken into account. It is also important to take note of the next aspect. Namely, you have to understand the legal environment in the receiving country. If you want to send the data to the third country, you should not assess the adequacy of the third country as to compliance with data protection requirements. Here you have to assess this very narrow case when you transfer your data and the particular laws that apply to your individual particular case and not this general data protection environment in the country. And that's why these mechanisms, assessment mechanisms can really vary. They can be selected on a case-by-case basis. So you have to look at the laws and how these laws are applied and complied with, in which cases it is necessary to disclose the data. Or maybe is it possible to delay the disclosure of data? What are the mechanisms or what mechanisms could be provided? Also, it is important to understand the sources of information that we use to assess this environment. Is this your personal experience or sectorial experience? Or, of course, better if these are objective assessment criteria, maybe some public organizations or NGOs have performed such an assessment. Also, you have to remember a point about the third point, namely the scope of processing of data and the legal situation in the country. Maybe it is necessary also to adjust the data protection guarantees in these cases, the safeguards. You can choose one of the three options or all of them. So because you have to choose specific safeguards, since contractual guarantees most probably will not suffice, you will also need technical and organizational guarantees. And legal guarantees maybe could involve specific law that describes the transfer chain. Organizational could be trainings, policies, implementation of multi-subject rights, and technical also would depend on specific cases like encryption, routing, and so on. But then it, of course, depends on each specific case. And also, what is very important in this case, data transfer requires a team. It's not just like exporter and importer deal with these data just by themselves. No, they have to cooperate. And for example, if the importer does not want to cooperate in gathering the necessary information, it's a good sign that you should not use this importer or cooperate with this importer for the purposes of transfer of data. And this assessment should be provided to supervisory bodies. And if you conclude that we would prefer not to send this data because the country is not safe and it doesn't work out that well, and the proof is not really adequate. It does not tell much about the country, but if the exporter still decides to proceed with the transfer, then the exporter undertakes the responsibility for these measures. And then, of course, we have to speak also about additional guarantees that would ensure the adequacy of the protection. Thank you. I hope that we will have a very nice panel discussion at the end. And now I'm ready to give the floor to the next colleague. Thank you. Very nice. And we will meet very soon during the panel discussion. And speaking about the next speaker, when I looked at the program, I felt like I will need to introduce a celebrity, because this is a person who has really fought for the protection of personal data. And he also represents a company whose slogan is "My privacy is none of your business." So a lawyer, an author, an activist from Austria, Maximilian Schrems, and he will tell about international transfer of data and protection of personal data from technology giants. Experience story. Hello.
Today.
Hey, thanks for the invitation.
Right, the floor is yours.
Oh, thanks a lot. Yeah, I was asked to talk about the so-called Schrems 2 judgment. It's still a bit awkward to have a judgment in your name. I usually call it the Privacy Shield judgment. I'm just going to share my slides here for a second. I hope you can all see that. Quick overview over this whole background, so to say. I think what's important for people to know is that we generally have a situation in the US where we have these two US surveillance laws, these two US surveillance systems under the same law. One of them is called Upstream, which is basically collecting the internet, the data on the internet backbone. And the other one is called PRISM, or now Downstream, which is the collection of data directly from so-called electronic communication service providers. This is now done through the FBI, basically, with a so-called direct interception unit. And they basically get the data from big hosting providers. These slides that I'm showing right now are mainly from Snowden. And you have to think that these are historic slides. They're about 10 years old. So we know, for example, that, Amazon is now part of the system, even though they're not in these slides because they just became big afterwards. What's kind of amazing here is that we actually have very specific information of how these surveillance systems work. Usually we just have a general idea of how these things operate. Then a quick part that I think is important from a European perspective to understand is the US surveillance law. So we mainly focused on FISA 702, that's also called 15188-1A. So it has two numbers, it's the same law. And in very simple terms, you basically need for surveillance under the US a so-called electronic communication service provider, so a company that is usually a cloud company, telecom company, and so on. And that company has to hold what they call foreign intelligence information. And that's a very broad terminology. So anything that is relevant for the foreign conduct of the United States, so international relations, espionage, and so on, falls under this definition. So it's much broader than just terrorism and so on. And that's kind of the two main elements you need. There is then usually certification for 1 year where the so-called FISA court approves a surveillance system for a whole year. And that's extremely important. They don't approve individual surveillance acts on an individual person. They approve a system like Upstream or PRISM in the abstract. And that's all that the court does. There is no further involvement for individual cases and so on. In these certifications, the US has to provide so-called minimization and targeting. And that is basically procedures to filter out American citizens and permanent residents, so US persons. Because what is done right now under FISA is definitely a violation of the US Constitution as well. But the US Constitution only protects its own citizens. So that allows the NSA to move forward without actually violating the
Max, we don't hear you, so probably something is wrong with your microphone, and you froze.
That is. You should be able to hear me now.
Yes, yes, we hear you now. Yeah, there's some interruption.
Okay, I haven't changed anything in my settings. Generally, if there's any problem further, you have to let me know.
No, it was just last 10 seconds, so just,
Okay,
yeah.
well, then there may just be a connection issue. Yeah, so basically there is this directive to the individual service provider that requires from a European perspective, I think it's important to reiterate that we basically have general rules that prohibit exports of data abroad. So we're not allowed to send data outside of the European Union as a default rule, which for a long time, I think people have not really paid that much attention to. And then there are so-called derogations for necessary transfers. And that's all the, I have to send, I don't know, an email abroad, stuff like that. In addition to that, there are situations that you can best describe as outsourcing. So basically when data has to be sent abroad, though even data doesn't have to be sent abroad, but it's easier, more convenient and so on to do so. And in these situations, you can basically forward data if you can guarantee that they're actually protected abroad. And that's exactly the big problem here. If you think about, for example, a country like Switzerland, it's not such a big issue because they have a data protection act that is similar than ours. And we basically can say this is kind of a protected bubble, so you can send data back and forth. If you have a situation like in the US, there is, first of all, no data protection act, so there's kind of a vacuum as on the first step. But we can fill that vacuum with SEC's Privacy Shield and so on. But in addition to the vacuum, we have the problem that the US also has a lot of conflicts with our laws. So we basically, under the charter, require privacy. The US requires surveillance, and that basically conflicts with these instruments because you can fill a vacuum, a lack of law abroad with SECs and so on, but you can't override the law in the US with these SECs, Privacy Shield and so on. And that is fundamentally why all these transfer mechanisms gradually always lose at the Court of Justice or are smashed because they simply can't override American law. And that is fundamentally the problem that we have, and I also fail to see how we can overcome this problem without changing US law at the same time. In my situation, just as an idea, my data was basically under surveillance, probably under Upstream and PRISM, under FISA. There's also a so-called 12333, another executive order that also allows upstream surveillance. And there is a so-called Presidential Policy Directive 28 that limits it to a certain extent. But long story short, my data basically can get intercepted the first time when it goes through the international cables, and then a second time once it arrived at a server in the US. And especially that second part is extremely relevant for the situations we usually talk about. We brought these cases up to the whole European system. We basically got a violation of the essence of a fundamental right, which for the Court of Justice is a very extreme thing. They usually don't have that. And we had a couple of other findings that I'm just going to jump through just to keep somewhat in time. Bottom line from the two judgments, and in my view, is that we basically have to have so-called essentially equivalent guarantees abroad, which there is some leeway. So it doesn't have to be exactly the GDPR, but it has to be more or less the same. But in relation to the US, the big problem is that that also has to be compliant with the Charter of Fundamental Rights. And there is no leeway here. There's basically full compliance with the Charter or not. And that is where these systems usually broke. So we mainly focused on the Charter rights. So your right to privacy, data protection, and redress, not that much on the actual commercial side of data protection under the GDPR. So in the second round, we basically had core arguments from Facebook that they said that the surveillance is not going beyond what EU member states do, so that there's no problem. In very simple terms, they said, if the UK is that terrible, then we can be that bad as well, because within the EU, there are member states that are not ideal either. We basically said that there has to be a specific enforcement action under Article 4 of the SECs for so-called FISA companies or for companies that fall under the surveillance law. So we called that a targeted solution for FISA companies. The Irish DPC had a very extreme view. They basically said that there is a systematic problem of the SECs, that they cannot do anything about it, and that Article 4 is not an option. And therefore, they wanted to invalidate the SECs. I personally don't think that the Irish DPC actually believed in any of these arguments, but it was an option for them to bring the case back to the Court of Justice and save their face somehow in not making a decision. So actually no one actually wanted to invalidate the SECs other than the Irish regulator. But the court basically settled with the middle option, with the targeted solution. I'm going to jump that quickly as well. And I think what's important now for everybody is what are the practical consequences of these rulings, of this kind of targeted stop of data transfers when there is a FISA company. So we basically look at this outsourcing situation, this situation where data is not necessarily sent to the US, but it's just more convenient and so on. And where basically we try to expand the GDPR rules to non-EU countries and how much that is possible or just failing. Obviously, if there's no personal data, we don't have any problem because we don't fall under GDPR. If we have what I call necessary transfers, that's not the correct legal term, but probably easier to understand, but basically the transfers under Article 49 of the GDPR, the Court of Justice has highlighted that they continue to be legal. So if you have a booking or an email you have to send abroad, that is something you can still do, and you're absolutely legal in doing that. The big problem is if you transfer data to a so-called electronic communication service provider in the US, and I think it's important to highlight it's these FISA companies that are the problem. It's not the whole US, it's not every US entity, it's just companies that fall under these surveillance laws. However, they also fall under these surveillance laws if they have a server in Europe. So oftentimes the big companies are now trying to promote to say, oh, but we have a server in Frankfurt, so everything's good. The reality is that FISA also reaches abroad as long as a US entity has what they call custody, possession, or control of the data. So as long as the data is somehow reachable from the US, technically, then they have to provide that information to the NSA. So what's crucially important is that we would have to check if anybody in the chain actually is falling under these US surveillance laws, and if they can factually reach the data in the European Union. There may be situations where there's only an American shareholder that doesn't have technical access to the data. That would be okay. However, if there is a global network where all the servers are interconnected and just one of them sits in Europe, that would probably not fulfill that test. However, there's also the situation that the recipient in the US does not fall under FISA. So it's just a normal recipient, the normal company that is there. And in these cases, I see no problem whatsoever to use the SECs. So it's a bit more nuanced oftentimes than just US or not. It's more geographic, jurisdictional about FISA if you fall under this law or not. Finally, just real short on the so-called supplementary measures. I wanted to mention that we brought the supplementary measures up at the Court of Justice. We said that there may be options in some very limited circumstances that you can bypass the problem with supplementary measures. However, if you think about them, there's basically technical supplementary measures that boil down to some kind of zero knowledge, so that the US entity that gets the data is simply not able to use the data because they don't have the keys, they have no access to the keys, the data is somehow else encrypted. So if you have some kind of zero knowledge bubble, you can make sure that the US entity can say, I don't have possession, custody, control of the data. I have it physically here, but I can't use it. I can't give it to you. And that would probably get you outside of FISA and US surveillance. However, what we see mostly is contractual things where they basically say, oh, we're just trying not to disclose stuff, or we inform you about the situation if we disclose stuff, or we're just going to resist whenever possible. All of these contractual systems are not really helping us in the US because US law simply does not allow for any of that. It simply says you have to be quiet. You're not allowed to talk about any of that. So I think that's also reflected in the case 6 and 7, especially of the EWB paper, which I would point people to because that's kind of the most common issues that we have. If we look at reality, we have these supplementary measures now of a lot of these larger US companies. So for example, Microsoft had these supplementary measures. I joked about it on Twitter that literally every one of these supplementary measures are at least a requirement under the GDPR anyways. Oftentimes they are even lagging behind the GDPR So, for example, they said that they would give damages to people in certain situations. However, under the GDPR, everybody has the right to damages anyways. So there's really no additional element here, and there's a lot of PR, a lot of blah blah, that is not really getting us closer to any solution right now. We have the submissions from Google recently in Austria where they said that they put out fences around their data centers and a sign saying "Do not enter," and basically tried to sell that as a supplementary measure, when in reality we know that a situation like pictured in this here is not gonna, you know, overcome FISA in any way. Facebook in recent submissions was even funnier. They basically just said that the Court of Justice was wrong and that US law is fully adequate and therefore they don't need supplementary measures. That's their main line of argument. So despite losing at the Court of Justice twice, they just pretend the Court of Justice hasn't said what it actually said. So I think there is this idea of a next agreement, of some hope that there's going to be something like that. I don't see it coming right now for all the reasons I've outlined before, unless there is really change in the US law. It seems more that the US industry and the US government are still trying to keep this hope somehow alive so that people do not act or wait for such an agreement before they take action. And I think that leads a bit to this paralysis we're in right now, where the authorities wait for the controllers to take action, the controllers wait for the authority to give guidance, everybody waits for the European Commission, the European companies wait for the American companies to provide services that are compliant. The American services say as long as people don't cancel their contract so far, we're not going to provide these services. So it seems everybody's kind of like sitting around and waiting to a large extent, with some notable exemptions though. Finally, I think as a positive note, there is not really a solution we can provide right now as lawyers. But I think the solution could lie in some kind of a, as you call it, no spy agreement, so that there is a protection of your privacy independent of citizenship. And that even if you're a citizen of a foreign country, you still have your fundamental rights. And that could allow companies to still process data in the long run and have a free flow of data. In very simple terms, it's a bit like if you're Switzerland and you want to keep all the data of the world, or all the money of the world, you have to give some guarantees to your customers that are abroad. And I think that's a reasonable demand towards the US as well, to say, if you want to be the, so to say, data keeper of the whole world, it's reasonable that foreigners also get some rights to this data. And that is what we are hoping to work on and be able to enforce in some way. I hope that was useful, and very sorry that I had to be a bit last minute because we had some major Corona issues here.
All right, Maximilian, thank you so much for joining us today. I know it wasn't easy for you, and best of luck in your activism. You are doing a good job for everybody here, at least in Europe. Definitely.
Thanks a
Thank
lot.
you. Thank you so much. Bye-bye.
Talk to you, bye.
Nu, ko mēs turpinām mūsu programmu un
We continue our program, and I am looking at the following, that in the very last moments, we have a person from Data Inspectorate. Otherwise, it would be rather bizarre, because we just had the director addressing us initially, but now we have Lauris Lindebergs. He is responsible for international issues and has been the expert on the advisor group on Schengen system level, security level provision in Portugal. So ensuring protection level after Schrem 2. I was in Portugal a long time ago, and it was warm there. We have heard about Schrem 2 case law from several speakers. That's why I will try to fit into time and leave more time for identified problematic issues. Even more, that the fifth part of the regulation concerning personal data protection is as many as there are. So I can enumerate them, but it's unnecessary to do that. A bit nuanced view on on some issues. First criterion that I wanted to mention for sufficient protection is just sound understanding or common sense. Because none of the legislative acts can provide the initial evaluation. Neither automated or semi-automated processing of data is as good as common sense. So that's why when speaking about sending data or transferring data to USA or any third country, first of all, we have to understand that we speak about electronic transfer of data, processed by a machine. So we should actually implement real risk assessment for that, and previous speakers spoke about that. After evaluating risks, we should come up with proportionate solutions for safety measures and privacy, insurance of privacy. And there might be different risks involved for data subjects. That's why necessary measures are different in order to really protect data and to ensure protection of data. We understand that theoretically there might be different scenarios, that there might be someone getting to information. In the case of USA, those theoretic scenarios have been studied by experts and specialists, and they are not as theoretical as it might seem. In case of other countries, the threats could be rather theoretical. For example, we are studying through platforms, and many of them are based in third countries, especially for learning English, for example, in USA, and it's very less likely that Jelgava Secondary School will be surveilled by USA surveillance agencies. That's why, for example, safeguarding and safekeeping exercises for studying language should not be overburdened with all kinds of safety measures. Additional safety measures that should be implemented are up to the managers or supervisors or all those responsible persons who were mentioned in previous presentations. Also, relations between supervisors, between data managers, data processors. After Schrem's case law, nothing has changed gradually. Namely, the articles of the regulation has not changed. The first article that we should take into account is Article 45, that data should be transferred in case of a certain level of protection. And the Commission can take a decision, and it means that no other additional measures should be applied for such an exchange of information. So we have this safe bubble of information being transferred. We believe that information exchange between EU countries is safe and safeguarded. But again, based on Article 45, the number of countries about whom these decisions are taken since 2019, this bubble includes Japan, South Korea, and Great Britain, as well as USA Privacy Shield has been expelled or voided from this safety bubble. Another tool based on which safe exchange of information can happen is between public entities. That can be an instrument, legal instrument, for example, an agreement between public institutions. Regulation already foresees that these agreements should foresee adequate safety measures, for example, additional clauses, how a data subject can stand for one's rights indirectly and directly against sender and receiver. If those guarantees are given without binding agreement, in that case, you should go to Data State Inspectorate, who will go with this document to the College of European Data Protection, and they will evaluate whether it is sufficient or not, whether equal parties in data exchange have equal opportunity, in order to avoid situation when one of the parties and one of the member states is allowed to be less careful with data. If there is no data protection law in the country, a separate law in the country, then there should be, or it is advisable to have a binding agreement between the parties or between countries. The biggest attention in EDPS as working group and other institutions are binding regulations. First of all, there is an article of the regulation, number 46, paragraph 2, as well as Article 47. There are opinions, guidelines, speaking about binding regulations of the enterprise. I know that it is described or prescribed in 11 or 12 legislative articles, namely what are the obligations of data processors and data managers. All the binding measures prescribed by the law should be verified by EDAC in our inspectorate. And then our inspectorate receives opinions from other institutions that are concerned, and at the end, when taking into account other institutions, we come up with our opinion, as well as some amendments to the initial law. This is rather burdensome process. It requires enough means and time in order to adopt a final version of the legislation. Also, some opt-out possibilities were explained in the previous presentation, but those are exceptions. It is not for systemic exchange of information. For example, if consequences concern only one person, then most probably we can talk about opt-out or, for example, in sending request for a hotel reservation. But even speaking about hotel reservation, whether it is done from booking.com or it is done by the flat or hotel owner, him or herself. At the same time, when applying transfer of data under opt-out or exceptional cases, these exceptions are still subject to overall regulation of GDPR. Namely, there should be a proper proportionality in data management, as well as there should be legal grounds for processing data. Also, the data subject should be notified, etc. Some summary about what should be done before submitting data. We have to acknowledge, first of all, that transfer of data is about to happen. You have to understand what data can be and will be transferred, what will be the impact on the data subject. You should acknowledge risks connected with the submission of data to third countries, what risks are there or might be there, how you can mitigate this impact. You should ensure how you will formalize the tools for application of maximum security measures. Those can be technical, organizational, or legal tools. There might be a situation when only accredited data package can be transferred, already assented to and given by the person. In that case, we consider that high level of security is ensured. Also, we have to time to time revise our pieces of legislation, whether they are not outdated. Additional measures have already been described in the recommendations of European Data Protection College 1/2020. Also, individual requirements can be evaluated on the case-by-case basis. Additional measures should be discussed with data processors and data managers. So if additional requirements are placed on the table only at a later stage, the data processor might decline processing that data. So we, as data submitters, should initially foresee those in the agreement for the data processor, know all the requirements that are put on his or her shoulders. So we understand that transfer of data is ongoing. At the same time, measures that we have identified as necessary and as those who we would like to implement are no longer topical. We, for example, should look for alternative measures in order to continue the possibility to process the data. Thank you very much, the providers of information, for this presentation, as well as there is case law mentioned, and you can have a look at the sources used for this presentation. I hope it was useful. Thank you, Lauris.
Nekur tālu jūs nelaiž, jo
And please don't go anywhere far because we will have a panel discussion with the panelists that you already met a few moments ago, namely Yulia Terjuhana, Anna Vladimirova Kryukova, lawyer, certified European and Latvian data protection officer, and also Lauris Linnebergs from the Data State Inspectorate, who is the head of Inspection and Prevention Division. So I don't know to what extent we take preventive action when we use various US-based services, and do we really ask ourselves how much they know about us? I have seen various documentaries, and when you watch these movies, you decide, that you have to delete yourself from the Facebook, as if you could really get yourself to delete it. I once tried to do that, and what they said was that, we are sorry that you are leaving. We and your friends will be waiting you back. Now we have a panel discussion. Actually, we have lots of questions, but we also have quite a lot of time. And I see that there are quite many questions sent via the platform. If I had to give the give the prize for the most active sender of questions, I would give this prize to my opponent, but since I don't have a prize, we will do without it. So colleagues just provided me some information, and let us have a look at what we can manage to do during this hour. So main arguments for finding the US data protection regime non-compliant was the inadequate and intransparent control over the use of such data. The security services can just say that this is required for the defense purposes or national security purposes. They can just easily access data of Europeans if, of course, they use services based in the US. If we look at the Article 2A of the GDPR, matters of national security are not included in the scope of the regulation. Don't you believe that, considering this, that the US is actually being asked to ensure a stricter, higher level of protection than is actually provided in the European Union? Who of you feels that you can answer this question? Please raise your hand, or just let us know otherwise. Lauris? I think I was the first, but I think Mr. Schrems already answered this question quite well. Actually, here, it was not really assessed if regulation could apply to similar activities performed by the security services based in the EU. In this regard, it was assessed whether the US has a similar level of protection like in Europe. The court actually took into account our Human Rights Protection Convention, and I think it was Article 45 of the regulation, namely the compliance decision, whether the same level of protection is ensured as in Europe. And the court made respective conclusions. And so what concerns interference from US security services and its scope, it was found that the level of protection is not the same as in Europe, because in Europe it is possible to challenge, to appeal to controls interference of security services. These opportunities are greater in Europe, actually. Yulia or Anna, maybe you have something to add. Philosophically, maybe we can add that actually the state and the companies are closely interlinked. We cannot speak only about specific processing in like a criminal case. Everything is really closely interrelated, as it was described by our guest in his presentation. So I believe this is the most important that we need to take into account, and why we should not exclude transfer of data to other countries from the scope of the data protection framework, namely to what extent private companies can disclose information to national bodies. Speaking about these US security services, Lauris already mentioned doing homework on a US-based platform, like 4th graders from one of Jelgava primary schools. So do you think that this comprehensive limitation of data transfer just on the basis of purely theoretical interference by security services, do you think that is commensurate, proportionate? I didn't ask this to anyone in particular, but maybe you can choose. Now, this is not really theoretical, because there have also been practical cases that have demonstrated what has happened. Here, it is important not to allow specific exceptions. I don't think that we can just close our eyes to exceptions. This is not commensurate with the regulation, because the risk is really high. And if we look at the regulation, it is based on risk assessment principles. And if we look at security requirements, here it is important to look at risks. And the risks are quite high. And this is what actually prevents international transfer of data. But I see that Julia wants to add something. About 4th graders, primary school number 4, since I live in the neighborhood. Yes, it seems like a joke. But in our daily lives, we do not really think about these things. That, for example, maybe in some time we will need to travel to to USA, and then the security services have a right to access our social media, to our whatever data that we have online, and this can serve as a reason not to let us into the country. And this information can actually do us harm, and this has actually happened. So in one or the other, from one or the other point of view, this can really adversely affect us. As to this comprehensive prohibition to transfer data to US, no, it is not prohibited because there are other alternative tools that allow us to do this. But the privacy shield, of course, it's not in force anymore. It's not valid. Here now in the center of Riga, and if I go outside, I would see people. And if I ask 10 people on the street if they have, if they use services of Google, Facebook, and whatever other giant in this area, most probably most of them would not see any significant risks in protecting their personal data. Or they would say, it's proportionate because I like the service that I receive, I see what my friends do, and we can easily communicate, or whatever other arguments they may have. Isn't it like that, we can just keep introducing these stricter data protection requirements, and eventually we start serving only a very narrow group of people who really focus on this, and they find everything wrong. But most would be quite happy, and they would say nothing. It has in no way affected me. Don't you see this lack of proportion here? Maybe we are not serving the interest of the majority. This is a philosophical question, maybe. Yes, thinking about this, and while I prepared for this panel discussion at home, yes, I thought philosophically, of course, that if we look at this bureaucracy and then bureaucratic burden that is imposed by the regulation and these regulations to those who want to export data to the countries that do not ensure adequate protection, yes, sometimes it works as a preventive means, and these operators do not choose the service providers that ensure storage of data in third countries or some other type of processing. They just choose Europe as the location of their facilities. In a way, I think this is also like fighting for the market. You can look at this also from this point of view. Recently, I read Anna, that people are ready to sell their data for coffee or a bar of chocolate, and this had been confirmed by many experiments. But actually, Facebook and similar service providers due to data, they are considered like something like alcohol or smoking. This is something that can actually affect your health. And that people maybe who don't have such a strong willpower cannot really give up these activities. And maybe quite soon we will have such warnings like on cigarette packages with these horrible pictures. So most probably we'll have new movies about this, how bad it is, how dangerous it is. But people will still require these services, and it will be our choice whether to use or not to use. And you will have to be careful with like US, because you can be monitored there and your data can be used against you, and people could choose themselves, I think, eventually. The main thing is to get informed, to give this information so that people would have an informed choice. And that's why the data regulation and other frameworks require this information to be provided, like in the case of medicinal products or something else. I think this will be a similar situation, that eventually information will be provided to people. We can conclude this from the WhatsApp decision or some other policies. That there are these specific requirements, privacy policies that people do not eventually read. It's not like this horrible warning on the package. Lauris, are you in Facebook? I had some suspicion, but I could not find you. I wanted to tell something very controversial. Recently, I saw a very interesting meme on Facebook. I am in Facebook, to answer your question, but the meme actually pertained to the initial questions that we had. The protection of the active minority and not the inactive majority. The majority claims, I don't have anything to hide, and who would be interested in me anyway? And the meme actually said, I don't care about protection of privacy because I don't have to hide anything. It's like I'm not concerned with freedom of speech because I don't have anything to say. But this is something so fundamental that you cannot really give up, like right to privacy, right to protection of data. These are fundamental rights. And not in all cases, this majority that is not really concerned with processing of information. I think that not always they know what is best for them and what is the right decision. That is one side of the coin. But the other side of the coin, like to avoid the development of technology and the fact that technologies will play an ever greater role in our lives. I don't know if they'll be very private invasive like Facebook, or maybe they are going to be not so invasive like Internet of Things, that will collect information about us and will allow to make conclusions about our daily lives. I don't think we'll be really able to avoid this. And we can't really stop the technological development. And if we even attempt to do that, we as Europe will become backward in this regard. And of course, we don't want that. We want the latest gadgets and so on. So I think we have to find some reasonable balance here. You know, you said I don't have anything to hide, and this made me remember one of last year's movies, who actually affected many users of social networks. It is called Social Dilemma. And do you think that it is in a way educational, this movie? Maybe it's worth posting a link. Is it relevant? Any experience or all experiences actually educate us. So with your permission, I will post a link in the chat. I see that Julia has raised her hand. I would like to add and agree with Loris what concerns those who say that I don't have anything to hide. You know, sometimes I read lectures to multi-ethnic audiences, international audiences, and I ask them to think about what sort of data protections they have in their home countries, like whether they have supervisory body, if they could actually effectively complain about data protection violations. And here I have to say that in a way we are spoiled by our rights. We live like in a bubble, and when I listen to answers, sometimes I just feel horrified. People say, like, in our society, people are not really interested in data protection. I can just hope that someone will review my application because I know someone in this body. Only then it will be taken into account. Or, you know, we are afraid of looking at specific content online because we know that we are being monitored. We are lucky not to have this, not to face this, but this is a reality in the world. And so maybe this can actually help us to educate the society that it is worth paying attention to various aspects of the privacy, of policies, and this will just make our society better, more educated. I had one question in my list. It was received, but Yekaterina Rokhin and Raymond Sarai sent very similar questions. Namely, people want to find out about practical solutions. How can businesses who want to transfer personal data to third countries, how can they assess the most important elements of the personal data protection system in these countries? Do you think maybe a support mechanism is warranted in this case? Our active viewers have sent in these questions. Maybe, Loris, you can start because you represent a public body. I think one of the tools that is already prepared and completed, I think Anna mentioned it. There are guidelines how to assess the impact of on data in third countries, and what other tools could be invented or developed. This is an interesting question. I think that can be asked to the business side, like what would help. However, it is clear that the inspectorate will not have the resources to do that for each and every controller, because that would mean analyzing every transfer case, like to learn each and every customer of the specific business and to understand the impact. I don't really think that any supervisory body could really do that, and the businesses have to make the first step here. But maybe the body could prepare a better toolkit, yes, that could be a matter of the dialogue, since businesses could then later use this toolkit. But if ZDAC has prepared the toolkit, or does the inspectorate really have to change it? Because then it would lead to non-uniform application that would contravene the spirit of the regulation. Anna, you'll be the next. I wanted to add to what Loris just explained. Of course, in the course of time, we will accumulate experience that we will be able to use instead of just copy-pasting, but by adjusting solutions. But I think this time is also a good opportunity for professional associations, because it's like at the time when we had to adopt professional codes of conduct. When this requirement was imposed, various associations actually prepared these codes on how data will be processed in the respective area. And this could be a good opportunity for associations, because usually the business operations, processing of data, and so on, members of the association usually have these practices in common. They are quite similar, and maybe these associations could actually find solutions. How to transfer specific data and so on. Do you mean like sectorial association? Yes. For example, a code of conduct on data processing. I know that in our country we have similar associations, and in other countries who have prepared codes of conduct on data processing. And I think associations have members with a similar, also maybe transfer to other countries' practices, and then it would be easier to find the common denominator. To reply to the comments from the audience, how to assess the practical impact, how to practically assess service providers. First and foremost, we have to read what they offer, because quite often the European customers are offered special rules, like our servers for European customers are in Frankfurt, which is quite a popular place for these purposes. So the large service providers have understood that they don't want to lose customers, and this is how they can comply with the requirements. So maybe you can consider such service providers who differentiate their customers instead of just outright sending everything to the US. So first and foremost, you have to check whether they are registered in Europe, and if they have, then they comply with what needs to be complied with. Even if they are not registered or established in the European Union, they physically separated the European servers in the European territory. So physically stores data in the territory of the EU. So they may not be established in the European Union, but they actually claim and promise that your data will be stored in Europe. What concerns large service providers, this has become a more common practice of late. People want recipes, they want recommendations. And we heard from Loris that Data State Inspectorate will do this for each and every business. And it's clear that you are quite a small team and you are tasked with very many issues. So this is a good opportunity for the private sector to offer some solutions, maybe even to make money on this. Anna? I would like maybe to answer to Julia, or to provide my comments on what Julia said. I think it's a matter for discussion. Yes, there is large service provider providers can claim that they store data in Europe, but can we really think that they are so safe? Because judging by the recommendations from the European colleagues, we know of a problem that, if my company is in the US, then there is this quite high risk that these US companies can access the European data, and this risk has to be taken into account. This may sound paranoid, but I think this is a reality that can really happen. And I think it was also mentioned in the judgment of the European Court. And it's quite difficult to understand to what extent this risk can materialize, because the requirements, yes, that's one thing, but the experience. But actually, in practice, we may have something else. So we should not really hurry and do not right away believe that everything is going to happen as written in the rules.
Īstenībā, piedodiet, ka es jūs pārtraucu. Jā, šajā momentā.
Sorry to interrupt, but or to step in. At this moment, I will agree, not oppose. This is also what our guest said, Mr. Shamp said, that there can be those decisions, for example, between one company that the data is not being transferred to USA, and if a daughter company is in Europe, request from US can reach it. This was heard during the presentation, and we should take it into account. Maya Opmane, our most active commentator in the chat, also says the same. The fact that the servers are located in Europe doesn't mean that the data is not transferred to USA. On the contrary, and again, a question about big servers, and Yekaterina is adding to the fact that we should take into account a Google example. So what to do? Why there is no Google and Facebook in Europe? Maybe because we have so many cultures and so many languages. We are not so united and unified as in US. Maybe you have asked yourselves this question. We should also look at investments in science in 1990. Some brightest minds went to Silicon Valley in 1990s. There was a brain drain at that time, and so they created a Facebook. So, but let's stay in our beautiful EU bubble. But now we have a practical question. What is necessary to implement in order to secure safe exchange of data with USA? So there can be immediate activities as well as long-term suggestions. So what could people use as tools at the moment in order to transfer their data? Maybe you have from your own experience or somehow else. We can, based on what Julia said, there are other mechanisms. For example, I can permit certain data being transferred to USA, as well as what Mr. Schems mentioned, that not all companies are being surveilled, not all electronic service providers, and you should have a look if your company is not working or dealing with companies that are subject to surveillance, then you can use those exceptional cases and send, for example, an email or register yourself by submitting data. Those are exceptions. But if we speak about big service providers like Facebook who are in the scope of surveillance. I understand, or as far as I've read, that EU is going forward in its negotiations with the USA, amongst other discussions that are not going to going so smoothly, as well as another interesting solution as implementation of interim or mediators who can be, for example, be located in EU. Data operators to whom data subjects would entrust their data, and they would do the filtering of all the requests from service providers. Of course, that is a huge project, and it is developing independently from transferring the question of transferring data to third countries. But the question is about the trust to that mediator, to that data processor. Let's move forward. I see that in chat, Alexander is asking a question with mentioning certain regulations and sub-points of regulations. Maybe you can have a look at the question and answer to that question, because there are very specific things asked. Maybe from your practical experience, maybe you've heard from about cases, percentage-wise, how often there is a possibility for medium companies or either bigger companies working with USA to amend the agreements, that they can come up with amendments and ask the big company in US to re-sign the agreement. No, we haven't heard of such scale companies as Microsoft or Google. No, they are unreachable, untouchables. Either take it or leave it, and you cannot amend your agreement. They are not going to cry over spilled milk in a form of some clients. Those are big companies with big structures. I can add the following, that it's interesting that their work can be influenced by activities of the public sector. For example, in the Netherlands or in Germany, the comments are the following, that in the state sector, in their meetings, Zoom cannot be used or Microsoft Teams cannot be used because the safety guarantees are not ensured. And maybe those big operators can be concerned about that. But without big sector, state involvement of a state sector, we can do nothing. Yes, indeed, when consulting big service providers, this is what we see. This is how they work. They, first of all, see how regulatory authorities work in the area of data protection and others, and then the enterprise evaluates whether to adapt to and comply to the regulation existing on state level or not. Oskars Bloombergs from chat is saying the following. It sounds that the only safe way to process data is not to process data at all. Is it really not possible to do anything without ensuring safety? Do we close with this statement, with this negative emotion. I'm very sorry to hear that, because I thought that our task was to tell about risks and to come up with solutions. I hope that this comment was written before we spoke of solutions. This is not indicative. Okay, this is personal, but me as well. I didn't have a full understanding of what I should do. So USA islands and European bubble are not the two only islands. A question about other countries. Why other countries have only theoretical threat? What about China, Russia, Belarus? Do you think that they have better data protection than USA? No, I don't have this opinion that, and it cannot be the opinion that they do not have any threats to data. Maybe our focus with USA is big because we have big information flow between our two regions. Also, we have case law. Maybe we should worry also about India, China, having technological giants and processing a lot of data and being mediators in the data processing. So namely, what is happening in those countries and what are the powers of surveillance and other law enforcement bodies. So we should be thinking of coming up with additional safety measures. All those tools that we spoke about in our presentations that can be used for ensuring adequate safety measure can be applied also to any other country, not only to USA. And I wanted to add about the safety. I wanted to take it over from someone else. Unfortunately, I don't remember where I heard it. He said that there is a correlation between safety and comfort. So the bigger the safety, the smaller the comfort, and the smaller is the comfort, the bigger safety. So we have to find this balance between safety and comfort. Yeah, if you are not going to process data, then most definitely there will not be breaches of data processing, but it will be very uncomfortable for you to live without your data being processed. But if you will ensure give the data to everyone, right and left, then at one point you might encounter some problems, and you will no longer be safe. If you are sending by mail €5 note, there is a likelihood that someone is going to steal these €5. It is more convenient for me to go and bring those €5 to a recipient. But that is absolutely uncomfortable for me, although it's much safer. Speaking about China and India, Americans themselves were very worried and flashed about use of TikTok, and many people spoke about prohibition of TikTok. There are not only children using TikTok, but also adults. Ernest has asked a question about digital nomads. It is November. If a Latvian can survive November in Latvia, he or she can survive everything. Someone is saying, no, I don't need it, and I spend the winter somewhere else. And together with this person, his data is traveling, data that he transmits. And the question lies, some years ago, I asked the question to Data State Inspectorate, and I received an answer that there is no, I forgot, what did they say? Whether an employee going abroad to spend the winter abroad, and he continues his or her work remotely, working, of course, with data and transmitting and receiving data. So your practical suggestions, our viewers are representing their respective organizations, and how we should look at these issues when continue working remotely from another place of the world. I will now think loudly. Hello, Arne. The fact that your employee will access the data from abroad, I don't think that he's a data recipient. He just accesses data and he receives doesn't receive data as a new subject. That's what I think. Do correct me if I'm wrong. And the second issue is the following. It's not a secret for Arnes to use additional encryption tools or some passwords for third persons not to be able to access your data. Those might also be private solutions. Lauris wanted to add something. Lauris remembers that I prepared a similar answer to a similar question some years ago, and what Lauris already answered goes hand in hand to guidelines of European Data Protection College. In this case, you should look at how permanent this location in another country of our employee is. Maybe this is unregistered branch office in another country. Then we can talk about transformation of data. But if it's a transit, a short time, or a vacation, then it's not a transfer of data. But if we talk about exchange of data in a network going through servers of a third country during the time while this employee is working in a third country, we should look at another the directive, not at the directive on GDPR, but on providing internet service providers directive. Okay, let us go to Jelgava Secondary School. I like this example. I would have never thought of a teacher. Maybe this teacher becomes a data manager because he or she asks to complete an exercise on class LV, where they have their unique profile. But then at the end, maybe we should ask for a teacher to have to perform certain activities and to have a certain status. And is it proportionate to ask that from a teacher? I can comment. We can speculate in two directions. First, if we agree that this activity is not okay, namely that this is a mandatory obligation to register, we, those who are for a longer time in data protection, we know that data processing should be done by data managers, hypothetically, but a teacher represents his or her employer. That is one thing. And the fact that if a teacher makes children to register in a platform doesn't make it a situation that at that moment a teacher can access all the data. They can see only information that is being sent to him or her. This is not data processing en masse. But we can speculate about that. What is data processing? We can split it in small pieces. What data goes where? What stays in the platform? What is accessible to the teacher? What can be managed by the child itself? Very simple questions, but at the same time, we can look at it from different angles, and nothing is black and white. In old days, it was not easy as well. If you cribbed from your neighbor in old days, then the teacher, if she caught me in action, she or he called me to him or her and said that you both will get only half of the mark. And this was not also data protection. So Maya had a question some time ago. She wrote in chat, and this question goes to Anna. Are you saying that the standard clauses are applicable in all cases and applicable to all countries? And how to measure proportionality of this requirement? Standard clauses is one of the basic solutions, with an except of countries that are in the list of European Commission. There is no point of making those standard clauses in agreements with those countries, because they have adequate safety measure, namely United Kingdom after Brexit, and some other countries. But concerning all other countries, standard clause can apply or cannot apply. It is up to the scale of transfer data, the amount of data, area, scope, participants, number of them, as well as I mentioned in my presentation. You have to evaluate the legislative framework of any given country, taking into account the circumstances, and then you can enter into standard clauses with that country or with an enterprise of another country. And in the case the conclusions are positive, or you come up with a list of risks, you elaborate organizational, technical, as well as legal clauses in your agreement. And then you re-evaluate the cooperation and the practice of data submission, transfer of data, and processing of data if something changes.
I've read the discussion in our chat as well, and Irene, I think, has a sort of question or comment, namely is that the commercial operators are forced to work in the environment as it is, including the international environment, and she believes that the public bodies should offer an alternative instead of just working with what there is. And that was maybe an answer to the question why we don't have Facebook in Europe, European Facebook. Let's speak about the following. I bought 1 terabyte of storage place for 80 euros in filium.lv. So you pay just once, and you always has this 1 terabyte in the cloud. And then I understood that there is no such cloud, like abstract cloud. It's just a computer of another person, and there I store important information. And I was told, like, look at the fine print for file of the service agreement of file MLV, and you know it's not safe and so on. And then I answered, you know, if I cannot upload the 2 gigabyte files and I call filem.lv and I sort out this question in 20 minutes, but I cannot do that with Dropbox, for example. But at least, you know, if they are not so huge and they don't have maybe that level of security, but they are locals and I can really privately reach them. So maybe the private sector can come together and create these alternatives so that we can really feel safe. So that it's not like Oscars wrote a moment ago that the best way or the safest way to process data is not to process data. Maybe this was my emotional invitation. So maybe you have a comment here. Maybe the private sector can do something here. Maybe Juliana, you can comment on this. Yes, I agree, completely agree with claims that we should create various services, including in Europe, on this side as well. But private sector, please remember that there are still rules applicable. So please read these rules, ask for advice, so that you would avoid unpleasant situations when like a supervisory body asks you for something, and if you don't comply, then you can be fined. So if you really want to sell yourself to an investor, I'm sure that investors will also look into what takes place in the area of your privacy, and this can affect the transaction, its structure, its amount, and all the other aspects, because privacy, in particular, if you deal with data processing as an important part of your business, this definitely is an area that you have to pay attention to. Our discussion is coming to an end, so maybe I can ask you to provide some summary, maybe with a view of the future, also taking into account the topic of our conference, namely personal data, future perspectives. So freely, maybe Lauris could be the first, like final conclusions. I think it's more of a slogan or invitation for safe, privacy-friendly protection of personal data in a technologically advanced digital environment in the future, not only in the EU, but in the rest of the world. Something like that. So we are for. You do, but we are for. We support this idea. Ladies, Julia maybe, or Anna? A very nice invitation, and I really hope that we will be able to experience that in practice in the future and see this being materialized. And it's a pity that we don't have our guest here, because I'm also interested in what will take place in the political arena, what will be the third mode of cooperation in this area between the US and Europe. And he is also could be the person who could, in a way, provoke this regime or this mode to make sure that it offers adequate protection. I checked the sources of SHREM association or union of activists, or on whatever forms they have chosen to work. By the way, they also collect donations to support their cause, and I think they have collected already 70%. Maybe you can also contribute to their activities. I can say that, you know, we have not agreed about this with Mr. Shrem, but I really felt that they are doing something very useful. Anna, the supervisory area, the objectives, the tasks, and the results sometimes seem negative. the current regime has been destroyed and there is no new mode or new regime yet. And then people can ask what to do next. But I think in all such situations there are always challenges and always possibilities, like to develop new services, like in Europe. Then there is also a challenge to move forward and to ensure the protection, also in cooperation with the US, if possible. And I think everything is not as bad as Oscars claimed. And I think in the course of time, the situation will definitely stabilize and we will have solutions and there'll be some established practice. And we will not really have to invest so much effort and so much time in this process. We just have to give it time, like to any opportunity. So this area is not yet developed, but this will be in the course of time done, and all these matters will be solved. I'm looking at the chat now, and I have two maybe slightly opposing comments. Irene says that in the public procurements, for example, some features that Zoom offers, but Phylum.lv does not offer, are required. So I will convey this message to Phylum.lv so that they could really satisfy the demand. And Arnis is quite brief, and he says, to business, I would just recommend consult the professionals. And the list is quite long, and there is a link to the link of the data protection officers. And now we can conclude our discussion, our conference. Congratulations on the 20th anniversary of the Data State Inspectorate. I wish you the best of luck in fighting, in the fight or in the protection of our personal data. And today we saw that things are not as easy and as simple as they seem in this area. And thank you to the panelists. And to conclude the conference, on my side, from my side, I can say that though I moderate many conferences almost every week, but I was quite surprised by so many participants, so many stages, like more than 1,005 stages, experts from various countries. A wonderful day, and I have to say that this day will be recorded, available in a recorded form for the entire month, for the next entire month, so you can always find it online. Watch this conference again, listen to the presentations, and maybe in this way you'll be able to see some things that you didn't manage to see due to parallel sessions. Also, I was told that on YouTube, the Data State Inspectorate, and this is yet again an American platform, so the Data State Inspectorate will post this on YouTube, and you'll be able to access this information there. If you require a certificate that is needed for the purposes of professional top-up, this certificate will be automatically sent to you. If not, please let us know. And before we leave, let us look at what Dr. Andersson has prepared for us, our artist. As I suspected, this is very intensive. This is how we looked like from the artistic point of view in this afternoon. I hope that this day was very useful to you, and I wish so many, and I wish such anniversaries to be more often, and I hope that such conferences will take place at least once per year. My name is Oskar Sprieda, and I was very happy to participate and to find out so many new things. Thank you to everyone who was active in the discussion and who emotionally expressed their concerns. Thank you and goodbye.